spinning circle is you, I think.
Do you have two of them is what I'm saying. Now that I'm here.
No, I only see one of you.
Okay, that's good.
Yeah, can't bill twice there, Miss Stevens. Not for two pictures.
Well, and this isn't really that much better, but after Friday's meeting, I tried to reboot my whole setup here, and
It would be twice as nice.
No, I'm afraid it still looks kind of blurry to me. But
yeah, it does look a little blurry.
Yeah,
hey, just to let people know, the Anna
part of that is I don't want the wrinkles to show, right? But there's a limit to that. No,
the YouTube is on.
I actually did a Zoom practice with my son, who made a few adjustments and gave me grades for clarity and said maybe it was your system. But I will.
Well, feel free to talk to the IT people. Way above my
maybe if I come a little
system.
Closer. I don't know.
Okay, are we gonna have any issues that we need to discuss procedurally? Again, just to notify the parties that are already in attendance, which good morning to you all. Welcome. Hello there, Mr. Schiestel, who is named Victor Martinez.
Yes.
Didn't know you changed your name there, sir. Are you going to be two witnesses today?
I'm trying to enhance my credibility by
changing your name there. Okay.
All
right.
That might work.
We're having some technical difficulties changing the name on here, so we probably will be, all of us will be Victor today unless we can figure it out.
Okay.
I think that's just disabled because I usually change my name from Stelzner Law to Keith Herman.
Yeah, normally you just click on it. You just click on the little ellipsis up there, and it gives you an option of changing the name, but it's not doing it. So you're right. It might be, maybe it's disabled, but we got our IT people looking at it. So
okay, you gonna have a lawyer today?
Absolutely.
Okay. I was gonna say, if you're being Mr. Martinez, maybe you're gonna take on that role too, huh?
No.
Nah. Okay.
Mr. Schietzel has so many talents. Why not?
You think maybe that might be one of them too? Okay, so no
one
one
waiting
says
for Mr. Olson or Mr. Wexler then.
They should both be on.
Might be this was our time if we needed to discuss anything procedural before we begin. Everybody is hearing everybody. I think the only person I haven't heard talk, Mr. Black, can you say something so we know?
Yes, good morning,
there
everyone.
You go.
You're good.
Okay. All right. Well, it looks like then if we're not going to have anything procedural, I'll just update you.
We are. I mean, at the pre-hearing, you discussed the opportunity for the company to respond to reply to
yes.
Solz's, but oh, there's Jeff. But there are other questions. After the pre-hearing conference, I spoke to Ms. Olson about exhibits and discovery and such, and she made a point of reminding me that EPE's pre-hearing memorandum, section 5 of their pre-hearing memorandum, stated that they have an intention to object to the city and county witnesses' testimony to the extent that they believe it's outside of the scope of this proceeding.
Okay.
So and that obviously, I mean, just as I don't know whether you want to get to the merits of this right now.
No, I don't. I just want to identify any issues.
It does need to be addressed before we begin the hearing, because obviously there are implications for the company's testimony that will precede the actual appearance of the city and county witnesses, if that's EPE's intention.
Ms. Hearing Examiner, you are now the host.
to this meeting
Okay.
and I'm gonna leave if you don't need me.
Well, I always need you, Ms. Kippenbrock. I can't function without you. I know you don't like it when people say that, but it's the truth. And that's what we're here for, the truth and nothing but the truth. So
Well, then
thank you
I
so
wish good
much.
luck.
And I appreciate that too. And thank you so much. And again, I remind people we're on the YouTube already.
Oh, are we?
So yeah. So thank you. And we've got Mr. Wexler. And hello there, Mr. Wexler. How are you?
Good, thanks. How are you?
I'm okay.
Good.
Are you anticipating Miss Olson, or are you it today?
Miss Olson will be here. I think she had some child obligations, but she'll be
Okay.
off cam. We'll just switch when.
Okay. And then I think we had a new associate, or we had a Miss Harris
That's correct, Miss Harris. She's listening in on
on the YouTube.
exactly.
Okay.
Madam Hearing Examiner, one of our witnesses, Mr. Strudel, just said that he was having difficulty finding.
Anastasia, I've already corrected that.
You've taken care of it? Okay, thank you, Keith.
The YouTube link is up. I just sent the link to our witnesses for anyone interested.
Did you send it to Mr. Provencio too?
I included Mr. Provencio.
Thank you.
Okay. Any other potential issues before we begin our
Madam Hearing
evidentiary
Examiner,
hearing? Mr.
I
Harmon,
just want to check my audio, make sure I'm coming in okay, or if I should
You
switch
are.
to my.
you absolutely are.
Okay, thank you.
Although it looks like a different picture than usual. Usually I see the guitars in the background.
This is the Stelzner North office.
Oh, okay.
I offer anyone, we did hang a shingle, so if you can find my sign, I will, I'll buy you a beer at our local watering hole.
Would that be your office?
Okay. Well, I'm gonna go check my water, the water fountain for my cup. And right now I have 8:56, so it looks like we've got 4 minutes. I will just so if anybody's got like, any last minute calls or something like that, we'll be starting in 4 minutes. And thank you all for showing up early to discuss anything that we needed to discuss. I just want to let you know I am, if I appear to be a bit distracted, I am trying the real-time transcript function
Oh, wow.
today. So
Madam Hearing Examiner, I do have one quick last question before you walk away. Have any changes been made to the Dropbox since you sent the link out yesterday afternoon?
to the best of my scanning, the answer to that question is no.
Good.
No, everyone actually complied and have their documents in there by noon yesterday. Okay, I'm gonna go fill my water glass. I'll be right back.
Hey, Jeff, while we've got a little break, we've got some corrections to James's deposition.
Okay.
I'll get those to you when we have a break.
Yeah.
Or get them to the court report. I'm not entirely sure who gets them, but just in the sense that it might affect your exhibits you've uploaded.
Okay. Yeah. I think you get them to the court reporter, so.
Okay.
If
Good
you
morning,
want to
Mr. Lee.
send them to me, Mr. Herman,
Okay,
then I can perhaps attach them electronically and forward them over to Mr. Wexler, but for convenience, as long as they're not too lengthy on Mr. Wexler's behalf, perhaps you can let him know, but if the witness isn't coming up, I'll see to it that he gets the transcript.
okay.
They're very small.
Test.
Not really.
Babe,
Okay.
No, it's worse.
yes, please.
Okay. Mr. Lee, are we ready to go, sir?
Yes, Judge, let's saddle up and ride for the brand.
Okay. Not our first rodeo. Okay. Well, I don't see Mr. Wexler, but I think Mr. Wexler, are you there?
I'm sure he just stepped away for one there. There we go.
Oh, there's Miss Burns. Good morning, Miss Burns. How are you?
I'm good. I'm
Good.
just providing a short distraction.
Okay.
And here comes Mr. Wexler.
Okay. Very well. Okay, Mr. Wexler.
Good
Okay.
morning.
Good morning. Mr. Lee, if we can go on the record, sir. Good
Yes,
morning.
ma'am.
This is case number 23-00046. This is in the matter of the application of El Paso Electric Company for continued use of its fuel and purchased power cost adjustment clause, hereinafter referred to as an FPPCAC. This is the date, time, and place set for the hearing in this matter. My name is Elizabeth Hurst. I am the designated hearing examiner for the New Mexico Public Regulation Commission in this case. Along with me is Mr. Lee of Cumbre Court Reporting. Should anyone need anything to do with the transcript, you will need to contact Mr. Lee directly. I would like to indicate for the record that while the caption indicates this is in the matter of the application, in fact, on December 18th of 2023, El Paso Electric filed an amended application, and that's what we will be hearing here today. And just want to let anybody who is watching or participating in the Zoom that the case is being live streamed on YouTube. Any witnesses that are waiting to testify will be can listen in on the YouTube, and whenever you are admitted to the Zoom, please make sure to turn off that YouTube. Otherwise, we'll have a big echo effect. If I could have appearances, please, beginning with you, Mr. Wexler.
Good morning, Jeff Wexler, and also Carrie Olson and Angela Harris from Montgomery and Andrews on behalf of applicant. We also have Nancy Burns, the Deputy General Counsel from the company.
Thank you. Good morning.
Morning.
My understanding per agreement is that we're going to have Doña Ana County come next in the examination order, presentation order. So Mr. Herman, if you'd make your appearance, please.
Thank you, Madam Examiner. Keith Herman with the Stelzner Law Firm on behalf of Doña Ana County.
Thank you. Ms. Stevens?
Good morning, Madam Hearing Examiner. I'm Anastasia Stevens of Stevens Law LLC on behalf of the City of Las Cruces.
Very well. Ms. Souls?
Good morning. My name is Mary Lee Souls. I'm representing myself as a pro se party.
Thank you. Mr. Black?
Good morning, Madam Hearing Examiner and parties. My name is David Black, and I'm appearing on behalf of staff, and I am accompanied by co-counsel. If you would allow, I would like him to introduce himself.
Very well. Mr. Rossi?
Good morning, Nicholas Rossi for PRC staff. Thank you.
Welcome. Very well. That concludes our appearances for staff and interveners. I would like at this point to indicate that on April 13th of 2023, the New Mexico Attorney General's Office, now known as the New Mexico Department of Justice, filed a motion to intervene in this case. I'm not aware of them participating in either filing of testimony or appearing at the pre-hearing last Friday, the 21st, and they're not here today. Therefore, the Attorney General / Department of Justice motion that was granted pursuant to operation of law is now terminated for failure to appear. Okay, we had, I'd also like the record to indicate that no person signed up as was required in the notice to give public comment. There was one written public comment in that was filed. And just a second, I will find my note. This public comment was offered by a Richard Denman, who lives in Las Cruces, and indicated that he was a customer of El Paso Electric, and I can characterize his comment as being opposed to the application.
Good. Can you spell Denman?
Yes, sir. It is Denman. First
Thank you,
name, first name Richard. Okay. Prior to going on the record this morning, I asked whether or not there were any new procedural issues that we needed to discuss this morning. And I don't believe that we have any new issues. The potential exhibits have been downloaded per the order in Dropbox. We have 2 outstanding motions with regard to confidential testimony and a motion to strike that I'm prepared to address. And should there be other issues, we can discuss those. I'd like to indicate can you still hear me?
Yes.
Yes, Judge.
Okay, interesting. I just got a notification that my audio had been disconnected. Anyway, I wanted to indicate for the record that El Paso Electric did in fact comply with the requirements plural to publish, give individual notice, and put the application on their website as was affirmed by their declaration of proof of notice that they filed February 15th of this year. Okay. With regard to the request for confidential determination, it is my hope that we're going to be able to conduct this hearing without resorting to any confidential information after reviewing El Paso Electric's request and Ms. Soul's response to that request. I am going to determine that the cost modeling claim as it relates to purported confidential exhibits from Ms. Soul's MLS, beginning MLS 20, that those potential exhibits MLS 30 through 50 that refer to cost model and El Paso Electric's claim of proprietary algorithms, that information is deemed to be confidential. I believe, pursuant to our pre-hearing on Friday, there is no claim for MLS 23 or 26. 23 was or is bids for the W, capital W, capital E, capital I, capital M, or the also known as the Western Energy Imbalance. And I don't recall the M, but we'll get that in testimony if we need it. And then 26 is the Rio Grande 8 overhaul information. So those are no longer or no longer claimed to be confidential if they were ever claimed to be confidential. What I'm referring to is cost model purported exhibits 30 through 50, and I believe I can generally describe those purported exhibits as time periods of months of particular years with that are parts of Excel spreadsheets. So that's my ruling on that. Again, it's my understanding that El Paso Electric has provided that information in a public redacted way, and it is my preference that if we can refer to the public versions, that the parties do so. If that's not going to be possible, then we'll address that at the time. The other outstanding procedural issue is with regard to El Paso Electric's motion to strike. Parts of Ms. Soul's testimony, as well as Ms. Souls' response, which she emailed to the parties Sunday morning, and would be considered filed as of yesterday. I had indicated at the pre-hearing that I would give El Paso Electric, should it so choose, an opportunity to provide any brief reply to Ms. Souls' response to their motion. Mr. Wexler, do you have anything else that I need to consider before I make a ruling?
Just very briefly, the only issue that I'll address is the timeliness, which I'd say that the qualifications of an expert and whether testimony requires expertise is measured at the time that the testimony is actually entered or offered. Oftentimes that's actually in oral testimony. And indeed, oftentimes you see objections to testimony during live evidentiary proceedings on the basis that it requires special expertise. And here, Ms. Souls has not yet offered her testimony. And moreover, there was no deadline in the procedural order for motions to strike or challenge the testimony. And we certainly intended to, and we believe we did, move with all diligence in light of the other significant deadlines that we were dealing with, including our own testimony, rebuttal testimony, and we think that we filed in more than sufficient time prior to the hearing. So I think that's the only new issue that was raised in Ms. Souls' response.
And I guess I have to say that I'll start with a timing issue first. That, I mean, this case has been going on for a while. The parties had asked back during last summer to have the case held in abeyance so that they could have discussions and try to reach some, I don't know if it was an agreements, but that they were trying to, in my mind, what I thought I heard the parties say is that they were trying to reach some consensus on how the case should go forward, what time periods should be included, and that they thought they could do so. And I think to a certain extent that happened and resulted in, because as we're going to hear in the testimony, I mean, there's been several changes since El Paso Electric's last FPPCAC case had been determined by the commission, and I thought that was very positive, and on behalf of the parties, and very positive for the commission to get information in the record to answer those questions that obviously the commission would be interested in. So knowing that the case has existed for more than a year, and knowing that when I issued the procedure order back in December, there were a couple of changes to that, but still I thought that I mean, it gave almost a good 5 months for parties to have to do discovery and formulate testimony and come up with their legal strategies. Again, there was sort of a hiccup with the time frame that El Paso Electric needed to perfect notice, so we adjusted for that. Pro se intervener Souls was due to personal plans was going to be unavailable, and we moved the hearing date. So I think there's been some flexibility in this case, and normally I have believed that having the flexibility in the procedural order to not nail down every single potential thing and give it a deadline has not necessarily been my style. I've counted on the professionalism of the parties to raise things in timely manner, and as soon as the issue is known. And I have to say that filing the motion to strike almost 2 weeks after your witness's rebuttal testimony, which again, I moved the rebuttal testimony dates because of a discovery issue and the motion to compel, and the assertion that El Paso Electric was still going to respond to discovery. So I think your motion could have been filed sooner, Mr. Wexler, quite frankly. Especially, I think it could have been filed concurrently with that testimony rather than waiting those couple of weeks. Doesn't set real well with me, the delay in that. But you're right, I didn't include a specific deadline, and for that, be assured in future procedural orders, well, it hasn't been my practice before, it will be now. That being said, you're right, the testimony has not been offered by Ms. Souls yet, but a lot of the rebuttal, I won't say a lot, some of the rebuttal testimony of El Paso Electric witnesses specifically goes to rebut Ms. Souls' testimony. So I think in an effort to have an orderly presentation of the evidence in this case, I'm going to go ahead and give you a ruling on your motion and Ms. Souls' response to your motion. And that ruling is that I'm going to deny your motion to strike Ms. Souls' testimony on the basis that you can have the opportunity to voir dire Ms. Souls on her qualification if you think there's something else other about her qualification other than what she has put in her testimony. But I believe that based upon our administrative standards and the fact that we don't have to identically adhere to the district court rules, allows the commission some leeway in making a determination of the credibility of the witness and and ultimately how much weight, if any, that we afford to the testimony of any witness. So I think that ultimately that's what the commission looks at, is what should be the relevant determination here is the weight of Ms. Soul's testimony, and not actually the admissibility of that particular designation of whether it is coming from a lay witness or what is a purported expert witness. And be assured that I will consider Ms. Soul's, when I'm considering her testimony, I will consider what qualifications or lack of qualifications she has when I weigh the evidence of her testimony, just as I would with any other witness. Okay. I think with that, if there's nothing else procedural that we need to deal with, I believe we could call our first witness. And it's my understanding, Mr. Wexler, that Mr. Schiestel is going to be your first witness. Is that correct, sir?
That's correct.
Okay. And I see the IT support box. Oh, there you are. That you're up in the corner. Hello again there, Mr. Schiestel, aka Mr. Martinez.
Good morning.
Just for the record, for the YouTube people, there are name identifiers on the Zoom boxes, and due to some technical difficulty, Mr. Schiestel is actually named Mr. Martinez. Mr. Lee, would you swear in Mr. Schiestel, please?
Yes, Your Honor. Mr. Schiestel, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, nothing but the truth.
I do.
Thank you, sir.
Good morning, Mr. Schiestel.
Good morning.
Can you please state your name and spell your name for the record?
My name is James Schiestel. Last name is spelled Schichtl.
What's your current position?
I am El Paso Electric's Vice President of Regulatory Operations and Resource Strategy.
Do you have before you what's been labeled as EPE Exhibit 1, your direct testimony filed in this case?
Yes, I do.
Is that testimony created by you or under your supervision?
Yes, it was.
Do you have any corrections here today?
I have one or two. First, on page 1, since filing this testimony in December of 23, my title has changed. And so my title on lines 7 and 8 should read Vice President of Regulatory Operations and Resource Strategy. I'll mention that none of my duties relevant to this proceeding have changed. And my title is correct in my rebuttal testimony. Also on page 8 of my direct testimony, there's a reference to a case number on line 3. That number should be 00093 -UT. And that is all.
With those corrections, is the testimony true and correct to the best of your knowledge?
Yes.
If you were asked the questions that are posed in your direct testimony today under oath, would you give the same answers?
Yes.
Madam Hearing Examiner, EPE offers EP Exhibit number 1 into evidence.
Mr. Wexler, were the corrections identified by Mr. Cecil here today included in the version of EPE Exhibit 1 that was placed in the Dropbox?
I don't believe so, Madam Hearing Examiner, subject to check with Mr. Schichtel, in part because Mr. Schichtel was traveling yesterday, and so we were unable to get those corrections. We're happy to upload a correction page if you'd like.
Well, let me ask this. Mr. Cecil, you had an attachment to your direct testimony, sir? You actually had 4. Is that correct?
Exhibits? Yes.
And those were prepared by you or under your direction and control?
Yes. Actually, I'm sorry, there's 5 exhibits.
Yes, you're right. There's the last graph. Any objection to what's been identified as El Paso Electric Exhibit 1, Mr. Schichtel's direct testimony as corrected by him here today? Hearing no.
I don't have an objection, but I do want to preserve an issue for when it comes to EPE's stated objection to Doña Ana County and City of Las Cruces witnesses, Mr. Stradell and Mr. Trethaway, regarding the inclusion of data after 2023. EPE has not made this motion, and I would argue that that information was included in EPE's application, which I haven't identified every instance where company witnesses reference data outside their asserted period, but if that objection is raised and sustained, it would affect objections we would make to company testimony.
Tell me the time period again, Mr. Herman.
I believe it from El Paso Electric's pre-hearing motion, they would like to object to data outside of 2022.
And are you saying that there's data outside of 2022 in EPE Exhibit 1?
We haven't gone through and identified every instance, but it is contained in EPE's amended application. And I presume, without seeing a written motion to strike from El Paso Electric, I just presume those references are prevalent throughout El Paso Electric's application and various testimonies.
Mr. Schichtel, do you know if you referred to any data outside of 2022 in your testimony?
I don't believe so. I was just looking at the exhibits. Those all end in 2022.
Okay, well, I'm not going to engage in speculative shoulda, coulda, woulda. So do you have an objection to this testimony, Mr. Herman?
No, and
Okay, very well.
thank you.
El Paso Electric Exhibit 1 is admitted. Mr. Wexler?
Mr. Schichtel, do you have before you what's been previously marked as EPE Exhibit number 2 before you?
Yes, I do.
And that testimony is labeled rebuttal testimony of James Schichtel on behalf of El Paso Electric. It's dated May 31st, 2024. Is that rebuttal testimony prepared by you under your direct supervision?
Yes.
We can see this, in this case, there are 3 exhibits. Each of those are previous, it looks like 2 exhibits, 1R and 2R. One is a final order, a second a report. Were those exhibits collected by you? Are you familiar with those exhibits such that you attach them to your rebuttal testimony?
Yes.
Do you have any corrections to your rebuttal testimony, EPE Exhibit 2?
No, I do not.
Is your rebuttal testimony true and correct to the best of your knowledge?
Yes.
If those questions that are contained within your rebuttal testimony were posed to you today under oath, would you give the same answers?
Yes.
Madam Hearing Examiner, we offer EPE Exhibit 2 into evidence.
Madam Hearing Examiner, the city objects to the admission of Mr. Schichtel's rebuttal testimony, basically on the same grounds that Mr. Herman just raised, except that substantial amounts of Mr. Schichtel's rebuttal testimony are addressed directly to the so-called February 2023 billing error issue. Also, throughout Mr. Schichtel's rebuttal testimony, he refers very generically to the arguments or positions, testimony of the city, county, and staff witnesses without specific page, references and things like that. So it's difficult to say exactly where he's drawing the lines in his rebuttal testimony. But again, large portions of it or substantial portions of it are about February 2023, and implicit in his discussion of February 2023, which I do not think he addresses directly, is another issue in February 2023, which is the fact that EPE reported negative purchase power expenses and negative purchase power revenues in that month. And these are questions that we just cannot wait till Mr. Provencio and Mr. Stridell and other witnesses come up to bat before you rule on the scope of this case.
And my question, your response, Mr. Wexler?
Yeah, I have 3 responses. The first is if the city and the county agree that the testimony from 2023 is outside the scope, we concede that also the parts of the testimony of Mr. Schichtel should be struck. And so we would agree to that on the condition that they also strike the parts that are outside the scope. In terms of the scope, as you know, Rule 550 requires a continuation period every 4 years. The continuation data period then is those 4 years that happened since the last case. And in this case, that data period happens to be 2017 through 2021. Now, early in the case, I'm sure Your Honor recalls, the party asked that we add 2022 so that there could be a better evaluation of the 12-month rolling average that had been put into place during the last rate case. And we agreed. And so we concede that the period of this case should be 2017 through 2022. To the extent that the city and county are interested in raising various issues from 2023, they'll certainly have their opportunity in the next continuation case, but that is simply not part of the overall data that's being evaluated and considered as part of this case by the commission. And then as to the third issue, which I didn't fully understand by Ms. Stevens, but that there weren't sufficient references in Mr. Schichtel's testimony to the testimony of either Mr. Streedel or Mr. Trethewey. Certainly Ms. Stevens can address that in cross-examination. I'm certain she can ask Mr. Schichtel to direct her to those portions of Mr. Streedel so that she can make sure she understands his testimony. Thank you.
Madam Hearing Examiner, may I be heard?
Yes.
Well, first of all, it would be better to probably discuss this between the attorneys rather than to ask Mr. Schichtel in his cross-examination, but there is nothing in the rule that says that there is a fixed continuation period. There's nothing that said that this period is 2017 to 2021. If that were true, it wouldn't be appropriate for the company to have decided to go ahead and change it. It also would not have been appropriate for the company to have gone into 2023 of their own volition to discuss the impact of joining the Western Energy Imbalance Market, WEIM. The core issue here is that the concept, both under the statute 62687E and Rule 550, that the concept of a continuation is to make sure that using a fuel clause mechanism at all, or using a specific fuel clause mechanism prospectively for the next period of up to 4, possibly 5 or more years. It's been more than 5 years since the last continuation order in 180006 UT, that a mechanism approved to be used prospectively with very limited, and the evidence in this case will show virtually no continuing oversight by the commission, requires looking forward, looking at the most recent evidence. You can't just say, oh, we'll look at it 4 or 5 or 6 years later. That's preposterous. That would be an absolute neglect of duty on the part of yourself and the commission to say, oh, there are problems in this fuel clause, but because there's this finite period of time that does not exist in statute, does not exist in rule, exists in EPE's mind, we have to just blinker our eyes and wait and come back 5 years and think about it. This is a prospective, rolling, ongoing mechanism. It's not retrospective, and it's not in the public interest to ignore real problems just because EPE says that, oh, they happened later than this fixed date that we would like to stop our analysis on. We can also show, not necessarily Mr. Schichtel's testimony, but in the direct as well as rebuttal testimonies of EPE's other witnesses, that the company has selectively used 2023 data when it suits their purposes.
Well, let me ask you this. If you've had this testimony for almost a month, if you didn't feel the testimony was appropriate, why didn't you file a motion to strike, Ms. Stevens?
I did not file a motion to strike because I interpreted the fact that EPE was rebutting the testimony on February 2023 and other post 2022 information meant that they understood and conceded that it was within the scope. EPE, just as with Ms. Souls, EPE had the burden. If they were objecting to the city's testimony, they should have done that before or at the time that they filed their rebuttal. And slipping a line in, I think it's Mr. Martinez's testimony saying, oh, we're thinking about filing a motion to strike. is just not adequate. It's not fair. It's not reasonable. It puts it puts all of us right here this moment, but it puts you in an untenable position. Because you're not reading the testimony the moment it comes in. You have other things to do. It's untimely and it's unwise because of the need to deal with reality.
Let me ask you, with regard to what I interpret as the improper form argument that you're making of Mr. Schiestel's rebuttal testimony, where in the commission's rules, the 1.2.2 rules of procedure, is it required that specific reference sites be given in rebuttal testimony?
There's no specific requirement. What it does, the rule does require is that for testimony to be considered appropriate, proper rebuttal, it must counteract testimony of another witness. For him to say something and say it counteracts testimony of another witness, it would be helpful for him to identify. It's not mandatory, but it's helpful. It's standard. I don't think it's obviously, again, another drag on this process. If I were to have to ask him for each and the other witnesses as well, he's not the only one, for, can you point to where in your testimony? And then he spends the next 5 or 10 minutes reviewing Mr. Provencio's testimony, Mr. Striedel's testimony. It's
not efficient.
Absolutely.
Okay.
But the main thing is that the timing, I have to think, as you sort of, I think, implied, if not just ruled in regard to Ms. Soul, the motion to strike Ms. Souls' testimony, is that if EPE had a problem with the scope, the issues raised in the city's testimony and county's testimony, city county testimony, it had opportunity. Rule 1.2.2.0, I have it written down earlier, 1.2.2.12A1 says that if the grounds are known, a motion shall be filed, shall be made prior to a hearing, except on good cause shown. And further says that the commission discourages any delay once the grounds for a motion are known. It's
okay. Very well.
Madam Examiner.
Do you also have an objection, Mr. Herman?
Again, phrasing this as an objection might not be the appropriate, but we do want to preserve this issue, as it might be more right to raise here with Mr. Schiestel's rebuttal testimony. But I did want to respond specifically to something by Mr. Wexler. First, that he would agree to striking all 2023 testimony. That is not the county's positions. We agree with him that this information is needed for better evaluation of the practices relating to the matter in this case, that is EPE's fuel clause. And therefore, we feel that all this information should come in, and the more information, the better to evaluate.
Very well.
We also second Ms. Stevens's position that if the company felt this material was objectionable at the filing of rebuttal testimony, that this motion or objection would be more properly raised prior to the hearing.
Very well. Mr. Wexler, response to Mr. Herman?
The last thing I'll add here, Your Honor, or I'll add two things. The first is the suggestion that somehow this was a surprise is simply not correct. El Paso Electric has, as you know, from the motion to compel, has been raising this issue throughout the case in terms of discovery, that this case is limited to the period for the continuation 2017 to 2022, and we have limited our discovery directly based on that. The only exceptions were 2022 and the WEIM, which again was a direct request, as you know, from the interveners. And then the last thing that I'll say on this issue is if Your Honor does allow testimony on 2023, then there should be a provision in the final order that essentially says that that issue, that year has been addressed, that therefore the issue is subject to issue preclusion and cannot be addressed in the rate case, because unfortunately, we see repeatedly in our cases the same issues over the same exact data, over the same periods being raised over and over and over again, and we'd rather just litigate those once. Thank you.
Very
Madam
well.
Examiner, may I say something there? Because
No, I
you
think I've
misrepresented the state of the discovery.
I spent days on the discovery issue, Ms. Stevens, and I'm not going to go back there. So no, I've heard enough. And let me say that I'm quite distressed that these issues weren't discussed on Friday. I mean, obviously, when I asked if there were any outstanding or any potential procedural issues that we needed to deal with, you know, I knew that the two pending, and I discussed allowing Ms. Souls to file because she had been unavailable to file a response to the motion to strike, you know, and that's all I was told. So, you know, I find it pretty untenable that the parties, you know, pull the rabbit out of the hat here the morning that we're supposed to be given our evidence. Very disappointed that this is how the parties choose to operate now. So very, very unfortunate. As I indicated in, well, let me say one thing with regard to Rule 550, and for the record, I'm referring to the Commission rule on fuel and purchase power adjustment clauses for electric utilities, and it is found at 17.9.550 and often referred to as Rule 550. And if you look at 17.9.550.17, which is entitled Continuation Filings, it says each utility operating with a FPPCAC as part of its tariff shall file an application for continued use of its FPPCAC at intervals of no more than 4 years from the date the FPPCAC is approved or continued by the Commission. I believe that is the standard operating procedure for electric utilities who have FPPCACs. With this late introduction of potential motions to strike because certain information may now be seen as outside of the scope. And I say potential because that's the way that it was phrased, that El Paso Electric might make such claims. And now the actual motion to strike the testimony, I guess, as a potential defensive or offensive action before someone files against them is very confusing, and I'm not going to rule on potential anything until I actually hear it. What I have here right now is an actual motion by the city of Las Cruces to strike Mr. Schiestel's rebuttal testimony as containing information outside the scope. I want to deny that. As far as motion to strike for it not being specific, there's nothing in the rule that says there has to be a specific reference in rebuttal testimony. So I'm not going to strike it for that reason. And then the third reason, that there's something to do with time period and the 4 years. I'm not going to strike it for that reason either, because the rule talks about 4 years. As Mr. Wexler indicated, I thought by holding this case in abeyance for a period of months and the agreement to include information about the 12-month rolling average and the Western energy imbalance market, I thought that cooperation and that information was a positive thing, but you all have led me to question whether or not that was appropriate. So your motion's denied, and what I want to say, though, in looking at the commission's procedural rules, and specifically looking at uh, 1.2.2.35 which is the rebuttal evidence section, as Ms. Stevens correctly identified, section N1 says rebuttal evidence is evidence which tends to explain, counteract, repel, or disprove evidence submitted by another party or by staff. Evidence which is merely cumulative or could have been more properly offered in the case in chief is not proper rebuttal evidence. And I have to say that if you look at El Paso Electric Exhibit 2, Mr. Schiestel's rebuttal testimony on page 3, beginning at line 15, the question posed at line 17, please summarize staff's recommendation regarding EPE's request for continuation of its approved FPPCAC. Then the answer beginning at lines 19 through 21 and continuing on page 4, lines 1 through 3, basically repeat staff's testimony. I don't find that to be proper rebuttal testimony. It doesn't meet the definition of rebuttal testimony. Additionally, if you look at page 5 of the same exhibit, lines 5 through 8, again, the staff witness recommendation is repeated in Mr. Schiestel's testimony. Further, on page 8 of the same exhibit, at lines 14 through 15, commenting on agreement with the staff testimony. I think that's cumulative. At least he puts his own opinion there. So maybe, maybe that one is more colorable. But, I mean, I bring this up to parties because, rebuttal should be short and sweet. It should be going within the scope of the rule to counteract, repel. And I just don't find that that some of this is appropriate. I'm not going to strike it, but I just bring this to your attention that going forward, if you have this kind of non-rebuttal testimony, I will take it upon myself to strike it. Okay. Having said that, having clarified the time period, having clarified what rebuttal testimony is supposed to be, if there's no further objection, El Paso Electric Exhibit 2 is admitted. Mr. Wexler.
We tender Mr. Schiestel for cross-examination.
I think now it's a little early, but I think now might be an appropriate time. Mr. Lee, can we take a 10-minute break at this point, sir?
Yes,
Are
Your
you all
Honor.
right with that? Okay.
Yes, Your Honor.
Very, very well. I have 10:06. Let's come back at 10:16 and we'll pursuant to the information that was given on Friday and was provided by the parties in their pre-hearing memoranda, parties have indicated how much cross-examination time they have. And we will begin with you, Mr. Herman. And I believe that you have reserved 20 minutes for Mr. Schiestel's cross-examination, and you may begin that at 10:16. We are recessed. Please remember that the YouTube stream will stay on.
Okay. You can be in the screen. You're perfect.
I'm just talking away to myself. Mr. Lee, can you hear me?
Yes, Judge, I'm ready when you are.
Okay. Mr. Schiestel, are you ready?
Yes, I am.
There you are. Okay, very well, sir. All right. Mr. Herman, you have some cross-examination for Mr. Schiestel. Go ahead, sir.
Thank you, Madam Examiner. Will you be keeping time or should I just keep an eye on the clock?
I will generally try to keep the time.
Okay.
Don't feel compelled to use it all.
I do not. I hope to not take that whole time, but if you could give me a 1 or 2 minute warning if I'm running
All
over.
right. I'll
Okay.
try to do that.
Good morning, Mr. Schiestel.
Good morning.
My name is Keith Herman. I'm here today on behalf of Doña Ana County.
Good morning.
How are you doing today?
I'm good, thank you.
Are you in El Paso currently?
I am.
And in preparing for your testimony, what did you review?
I generally reviewed all of EPE's testimony as well as the rebuttal testimonies, especially that I respond to, but all of EPE's direct and rebuttal testimony.
And when you say the rebuttal testimony or let's say the testimony of other parties, does that include the testimony of city county witness, Mr. Streedell?
Yes.
Did you review Rule 550 at all?
Yes.
And you're generally familiar with the workings of Rule 550?
Yes, I would say I am generally familiar.
Did you review any discovery responses?
I review discovery responses as we go through the process and the discovery process. I will go back and review my own discovery responses just to refresh my memory. So I've generally seen all of them at one time or another throughout the proceeding.
Could I direct you to EPE Exhibit 2, your rebuttal testimony? Specifically, page 16.
Did you say 1-6, Mr. Herman?
1-6.
Thank you.
Okay.
Specifically, I want to direct you to question 26. At lines 19, you assert that Mr. Streedell asserts that EPE's application of the 12-month rolling average FPPCAC fails to provide for the stability of utility earnings when electric fuel costs and purchase power costs are rising, and fails to permit prompt credits to customers when electric fuel and power or fuel costs and purchase power costs are declining. Did I read that correctly?
Yes.
You then go on to the next page at page 17 to state that, starting at line 3, EPE has experienced no financial issues or instability with fuel or purchase power cost recovery in New Mexico related to the monthly movements of the FPPCAC, correct?
Yes.
Do you know what the cumulative over recovery balance was for EPE's FPPCAC in January of 2023?
Not as I sit here, no.
Could I direct you to DAC CLC exhibit number 2?
If you give me a second, I'll find it.
Thank you, Examiner Hurst.
Thank you.
I was just going to offer to share my screen, but you said you reviewed Mr. Streetel's testimony. Do you recognize this full page print up of his graph? And Madam Examiner, if you could move to page 2 for graph JES2.
Yes, I recognize this.
So Mr. Streetel in his graph identified an overcollection of $52,240.
Yes, I see that.
Do you dispute that number?
I have no reason to dispute it. We were seeing very large off-system sales margins as a result of EPE's efforts in off-system sales, which are an enormous benefit to customers. And that was, I believe, December 22 was probably certainly the end of December, and December 22 were the source of a very large amount of off-system sales margins. So those are reflected as an over recovery of fuel because they go into the balancing account as basically monies that are to go back to ratepayers.
So let's go back to your rebuttal testimony. That was all the questions I have on that exhibit, Madam Examiner. So back to your rebuttal testimony at page 17, where you state that EPE experienced no financial issues or instability.
Yes.
In that particular sentence, you do not mention customer refunds, correct?
No, I was referring specifically to Mr. Streetel's testimony regarding stability of utility earnings.
And you do understand, or, you earlier testified that one of the objectives of Rule 550 is to ensure prompt credit to customers, correct?
Yes, when I think the reference is when fuel prices are declining. But yes,
That would all, would you agree that that would also stand for, you know, sales made that you just testified to having a windfall on?
yes. Well, I wouldn't call it a windfall, but a margin.
No, and if you're making off-system sales, I think that's activity we would encourage, correct?
I believe so. Yes, it certainly benefits ratepayers.
Exactly. So where in your rebuttal testimony do you address, or let's scratch that. Because I do want to discuss a little bit more about the prompt return to customers of excesses. So could we go to question 44? So starting at page 29.
Okay.
And there you're countering the assertion that the PRC should focus on balancing. Sorry, that's a mouthful of a question. Could you summarize that question, please?
Sure. This was in response to Mr. Stradell's identification of some policy objectives that he felt the commission should focus on. So I think the balance is customer certainty as to price of electricity and minimizing the amount and duration of over and under collections.
And you assert in the sentence starting on line 17, for example, an under-collected balance of 5 million in 1 month will be incorporated entirely into the next FPPCAC factor. No amount is held for future months.
Correct.
Now, I want to understand the mechanism you're explaining here, because if we can jump to exhibit JES2, which if you're in the PDF version is page 65. JES2R, page 3 of 8.
Give me 1 second. I have a binder here. Miss Rissa's testimony.
Or no, I'm sorry, JS. This is Jim Sheastel.
Oh, okay. Sorry about that.
I added an E in the middle.
That's okay. I added an S to her last name instead of R. So 1 second. Okay.
JES2R, page 3. That's a example of one of EPE's 550 report forms, correct?
Yes. One more second. Yes.
Look at the screen. It should be on the screen.
Thank you, Madam Examiner.
You see it?
Yes.
Okay.
It's a little easier to read on the paper copy, so. But I have it.
At line 7, you are showing a cumulative over/under recovery or under collection at the end of the current month, correct?
Direct me again on which page you're on. Sorry.
Page 3.
Yes, line 7.
Yes.
And that's
Okay, just so, wait, hang on just a second. Just so we're clear, when you say page 3, are you saying page 3 of 8 under the exhibit number, or are you referring to the page number that is alongside of the document itself.
Thank you, Madam
Document
Chair.
number or exhibit number?
I'm referring to page 3 of 8. I believe that's the exhibit number.
Okay, very well.
And that is the document you have shared with everyone.
Yes, I see that number.
Okay, so that's a cumulative over/under collection, correct?
Correct.
So I'm trying to understand your statement back in your testimony that a 1 month under collected balance is incorporated entirely. Because it appears from here that you're conflating the monthly balancing account versus the actual fuel clause factor.
So I'm sorry, I didn't follow.
Do you disagree with that statement?
So certainly the cumulative balance is not the only component of the fuel factor, the FPPCAC. If I understood the question.
So would it be correct then to say that when you say that the under collected balance is incorporated entirely into the next month, you mean that balance is incorporated specifically into the factor and not necessarily a dollar for dollar reflection of costs? Correct.
It is reflect, or is it is included in the fuel and purchase power expense for the month in which we're determining the FPPCAC.
Okay. Thank you for that clarification. That concludes my examination. And I apologize if I had any internet connection activities and didn't include all my pleasantries, Mr. Schiestel. I appreciate your testimony, but sometimes my internet connection can be unstable, so wanted to get my questions out first.
No problem. Thank you.
Very well. Thank you, Mr. Herman. You concluded with 5 minutes to spare. Very well. I believe the next party who has questions for Mr. Schiestel is the City of Las Cruces. Ms. Stevens, you have reserved 35 minutes. Please feel free not to use them all.
What, you're not going to give me Mr. Herman's extra 5?
Absolutely
No.
not. Please go ahead.
Thank you. Good morning, Mr. Schiestel. Could we close this view, because I'm nearly blind here, and I can hardly see Mr. Schiestel. Thank you. How are you doing this morning?
Good, thank you.
Now let me find you on screen. Okay. So before we go through your pre-filed testimony, I have some questions about the big objectives of this proceeding. Would you look at your direct testimony, if I can find, at page 24. Lines 11 to 13. You testify that EPE produces roughly 60% of the energy supplied to New Mexico customers annually through steam and combustion turbine generation is fueled by natural gas. You're aware, aren't you, that beginning in 2025, under the New Mexico Renewable Energy Act, EPE is required to provide at least 40% of the energy it uses for New Mexico customers from renewable energy, right?
Yes.
Can you point to anywhere in your testimony or anywhere in the testimony of other witnesses that explains how EPE's fuel and purchase power policies and practices are going to be changed as of January 2025 to reflect that requirement, the 40% renewable requirement, as well as the existence of EPE's continuing ownership in Palo Verde nuclear generating unit and existing gas plants?
Objection, it's a compound question.
Yeah, it is a
Okay.
compound question. Can we
Maybe
break
try-
that up there, Ms. Stevens?
So can you tell me I'll try again. Can you tell me where in the where, if anywhere, in the testimony, your testimony or the other witnesses, because I know you're the head honcho here, the company addresses how it's going to go from a world in which 60% of the energy supplied to Mexico customers is through company-owned gas generation, to a world in which 40% must be renewable and
Okay, stop. Okay, let's stop there and
and
go ahead, Mr. Schiestel. You can answer the question.
So I understand your question with respect to this case, where we're addressing the recovery of fuel costs in the FPPCAC. We don't address the future as to REA compliance. We have another proceeding in annual proceeding in the RPS plan proceeding, I refer to it as, where we've already filed for a 2025 plan year, where we demonstrate in that proceeding how we'll reach 40% renewables in 2025. I think that then going forward, what we'll see in the FPPCAC is a change in the fuel mix as we proceed down that path to more and more renewables.
so you don't believe that part of the obligation in this case to show that EPE's fuel and purchase power policies are designed to produce the lowest reasonable cost generation is implicated at all by this, sea change in the company's RPS during the period in which the requested continued fuel clause would be in effect?
No, and I don't think that our policies and procedures with respect to fuel costs for, let's say, for natural gas and nuclear resources themselves are really implicated by increasing the amount of renewable resources we have in the system. We'll still need to provide, even as the use of, say, combustion resources declines as renewables increase, we'll still have to do exactly the same thing. That is, assure to the extent possible and subject to reliability constraints that we're getting the lowest possible fuel costs for our customers.
Let's go back to the beginning of your direct testimony, please. I don't think I've done this before for years, Mr. Schiestel, given your experience, but I'm going to ask a few questions about your role. In the role that you had, which I think you've said at the time you filed your direct testimony, which I believe you earlier said hasn't changed your current responsibilities, even though you changed your title. Were you notified of EPE's February 2023 billing overcharge of $8.3 million?
Was I notified? Yes.
Yeah. And by whom?
I don't recall.
Do you know when?
It was my recollection. It was late February to early March.
And you read you rebutted, so I assume you read Mr. Jose Provencio's direct testimony, right?
Yes.
Do you recall his testimony where he explains which entities LCU, Las Cruces Utilities, notifies when and what action it takes when a billing error occurs?
I don't recall that testimony specifically. I do recall generally that testimony.
Do you recall his mentioning that notification goes up as high as the city council and goes down as far as customers?
I don't specifically recall that, no.
Does EPE have policies or protocols surrounding whom it should notify when and when a billing error occurs?
Yes, and it's as in my understanding, it's somewhat a function of the error itself and how many customers it involves and the nature of it, but generally, yes.
And is that within the purview of your personal responsibilities?
I would say I'm a participant in it. Yes.
So in this case, February 2023, the Delta billing error was $8.3 million, was it not?
That sounds correct. Yes.
What actions did individuals directly under you take upon learning of a billing error of that scale? Oh, and it affects virtually everybody, every New Mexico customer, right? Because it's a fuel clause amount.
Yes, every customer that pays the fuel charge. Yes. The first part of that process was making sure we understood the nature of the billing error, and then quantifying it, and then a discussion about the best way to deal with it. Certainly a communication with staff was appropriate. Since this was not the error itself was not really a component of the FPPCAC 550 filing for that month. That month included the correct factor. It was reversed in billing, but we did notify staff.
Has EP ever made an $8.3 million billing error before in New Mexico?
Not to my recollection, no.
Did you take it upon yourself, you or anybody at the company take it upon yourselves to notify the commissioners directly?
I don't believe so. We notified staff, as I said, but given our ability to essentially reverse it in the next factor, that was our focus at the time.
And did you notify the city or the county, officials at the city or the county or other municipalities within your New Mexico service territory?
Not that I'm aware of.
Did you notify any of your customers, large or small?
Of the specifics? No, not that I'm aware of.
Well, did you notify them, any of your customers, that, oh, your bill was too high last month because we made a mistake and charged you when we should have credited you? Did you not tell anybody that other than staff?
No, I don't believe so.
And did you notify, working upward now, it was a billing error of that sort? Did it cause you, and I'm using the you generically that way, did it cause you to notify the other important departments or individuals within the company, such as the controller or the chief financial officer?
Yes, everyone who was affected, say internally by the what amounts to an overbilling our customers in a billing error, we're aware of the problem. Yes.
And did that include the El Paso Electric board of directors?
No, it wouldn't have included the board of directors.
So, and you do believe that what as Ms. Reza testifies, that the company had an appropriate solution?
Absolutely. I mean, I think, we take this error very seriously, and we have taken steps to have extra levels of review to prevent this type of thing. It is a relatively simple error in the sense of it's basically, inputting a positive instead of a negative. I would note that one of the issues here is that it's sizable, partly because the negative or the credit to customers was so sizable. But the FPPC mechanism, it's a CAC mechanism itself, is designed specifically to deal with this. It deals with it every month as a matter of course. Over under collections are rolled back through the factor and corrected, and as we go forward, so they're immediately reflected in the next FPPCAC. It's a 2-month lag, but so the next FPPCAC after the month in which the overbilling occurred in this case, it was reflected in that FPPCAC, and that's really how the mechanism's designed, is to do that.
Mr. Schiestel, may I direct you to CLC? Oh dear. Exhibit. Looking for the February 2023 on my list here. CLC Exhibit 25. That's EPE's February 2023 FPPCAC filing. Have you got it?
I do.
Okay. And now the actual error occurred for billing December costs in February, correct? The actual billings that were reversed were for the consequences of December costs that were supposed to be credited during the month of February and actual February bills. Is that right?
That's correct.
And then this February 2023 factor filing statement is what you filed in late March to essentially pick up the 2-month lag and cover the actual recoveries in February and costs in February under the still existing 2-month lag aspect of the rule. Is that right? The mechanism?
Yes.
So if we go to work paper A, page 1 of 4, and I'm looking at line 33 there. And is it true that how EPE dealt with this billing, so-called billing error, is that they imputed the adjustment that was supposed to have been made in February on line 33? And if this is better questions for Ms. Reza, please let me know. Well, I'll save it for her.
Well, it is. Certainly she could answer this immediately, but I'd only take issue with the imputed, but the purpose of, or the process was to do that, yes, is to reverse the result of the billing error from December from February in the April factor. But she could give you more detail on exactly how all of this works through the calculation.
I'll ask her then. I will ask you whether since you say that it completely reverses, or there's nowhere on this February factor for April billings where that $8.3 million overcharge is directly reflected, is there?
I think that's appropriately addressed to Ms. Reza, but I'll say from the methodologically, that's exactly what is to happen. And as I said, it is consistent with the overarching FPPCA methodology, that when a over/under collection occurs in a month, that it's then reflected in the factor 2 months later.
Okay. So your position is basically that there was a billing error, not a fuel clause problem in
Yes.
February 2023, pardon me. And And therefore you conclude that that billing error and whatever the consequences are in terms of it flowing through the fuel clause is not a fuel clause problem, but it's a billing problem?
Well, in this instance specifically, the error occurred in billing. It was not a miscalculation of the factor in the 550 filing. That's my reference to it as a billing error. We used the FPPCAC to correct for what essentially resulted, which was an overcharge, overbilling to customers, over recovery, I should say, of fuel costs.
And in response to Mr. Provencio's testimony, you acknowledged in your rebuttal that that the company did have choices in how to deal with. I've lost your face. I'm sorry. There, that's a question. The company did have choices or options in how to deal with that billing error, didn't it? You acknowledge that in your rebuttal?
Well, I believe what I say in response to Mr. Provencio is that another option would have been to rebill, essentially rebill February, all customers.
Right.
Yes.
And that's, for all intents and purposes, that's what Mr. Provencio recommended. Is that right?
I believe so, yes. The concern there obviously is administratively and otherwise, it's more expensive, and it's also, I think, would have taken considerably longer than the approach we took.
Do you know how much it would have cost?
I do not.
And if you don't know how much it costs, Mr. Schiestel, how did you weigh, as your testimony, your rebuttal testimony at page 15, line 7 through 20?
I'm sorry, I didn't follow your page numbers.
I've lost out. My notes say page 15, lines 17 to 20. I'm going to look for it now, but
I have it.
okay. You're in a better place than I am. Okay. So this, you imply that there was a balancing of the costs versus the impact on customers. And you also, don't you, testify that the charges to the customer in that month, a typical average, we know that we're not going to get into the minutiae of what's an average customer, what's a typical customer, whether such a thing exists. But in your own words, the average customer bill for that month, that it was, the effect was $22.40, right?
Yes.
And going back to the notion that it was an overbill when it should have been in credit, we double that to get an impact to the customer from the customer's standpoint, what they have to pay out of pocket of $44.80. Is that right? Do you agree?
I believe that's the way Mr. Provencio analyzed it. My reference here is just that what it represents as a percentage of the total bill is pretty standard for a fuel charge. It isn't out of line from, say, a typical month. I usually figure 25 to 30% fuel is pretty reasonable.
Well, if EPE figured 25 to 30% fuel every month, even when costs are going down, it could really build up some large cumulative over recoveries, could it?
Yeah, I certainly
the idea of the mechanism is that it goes up and down, right?
I certainly wasn't implying that it's the same percentage every month. I'm just saying that it's not an unusual percentage to see in a fuel factor.
Okay.
But we've actually had net fuel factors in months be negative several times this year already. So there is a large variation, but a charge that size as a portion of the bill is not unusual.
So if you were a customer a residential customer, and EPE was supposed to give you $22.40 plus taxes and UERF charges and franchise fees. And instead, they demanded that of you. The total impact on that customer would be a larger proportion of the of the bill than 27%. Is that not so?
Yeah, I apologize. I don't really follow that. If your point is that the difference between what they should have been billed for fuel and what what they were billed for fuel is a significant amount of money, I won't disagree. I mean, I think it was, as I said in my testimony, a significant billing error. It was reversed in subsequent months, which was my point of referencing the FPPCAC mechanism.
Well, just for clarification purposes, Mr. Schiestel,
yes,
in what the takeaway from your testimony on page 15 lines, you're answering the question at lines 5 through 7, and that's the reference to this. And I've stopped your time, so I'm not impinging on your time, Ms. Stevens.
No, I appreciate your questions, Madam Hearing.
Is that the average customer used 688 kWh, and the FPPCAC component was 2240, representing 27% of the total monthly bill of 8363. So if are you saying that 2240 that they were charged was the billing error amount?
No, I think if you were to say what the billing error amount is, it would be the difference between what they were charged and what they should have been charged if we had inputted the correct figure. So the figure for FPPCAC that month was actually negative. So even though we had fuel costs that are reflected there, the amount of the over collection resulting from off-system sales was so large, it completely reversed the total cost of fuel and gave us a negative factor. The billing error was entering that number as a positive as opposed to a negative. So if you were to say what the magnitude or the difference is, let's say, between what should have been billed and what was billed, that was essentially double the 2240. That's a 4480, I think, is a fair approximation. There are other charges on the bill that work off of the total bill. Certain taxes is a perfect example. So there'd be some differences. But if you just wanted to say what's the difference between for FPPCAC, what would have been billed and what should have been, what was billed and what should have been billed, it's basically double that 2240.
So they should have had a 4480 credit that month?
No, FPPCAC should have been a negative 2240. It wouldn't have offset the total bill. They still would have had a positive bill in this example. But the FPPCAC factor itself should have been a negative 2240 as opposed to a positive.
Right. So, and that's for this average customer.
Right.
So when that got reversed 2 months later, was the minus 2240 put into the factor?
The total amount of the overcharge is reflected in that is for all customers, right? We don't, not on an individual customer basis, but the total amount of the overcharge resulting from the billing error is then reflected in the factor going forward in April. Which
Does
is
it-
what, I'm sorry, which I was just going to add is, which is what the FPPCAC mechanism does. Any kind of over or under recovery then gets reflected.
right? But it doesn't necessarily go back to the individual customer that was overcharged, does it?
That's correct, because their usage, especially to the extent that their usage is different in the subsequent months. That's correct. Again, consistent with the mechanism.
Right, right. No, I understand that. Okay. Thank you. Go ahead, Ms. Stevens.
Thank you, Madam Hearing Examiner. So, Mr. Schiestel, you just told the hearing examiner that the total amount of the overcharge is reflected in the April bill. But a few minutes ago, when we were looking at the February statement for April bills, I thought you told me that you don't see that $8.3 million total overcharge reflected, which
I'm
is
gonna object.
true.
I'm going to object as does not properly reflect the testimony of the witness.
And I'll overrule that objection. And do you understand the question, Mr. Schiestel?
Yes.
Okay, go ahead.
As far as it had gotten, yes, I understood.
Okay, go ahead, Ms. Stevens.
So
Do you want to look back at this exhibit?
Yeah, which is true? Was it directly and immediately and entirely reflected in April, or was it not?
It was, yes.
It was.
It was
And
included.
show
It
me
was
how- Can you
incorporated.
show us? Can you
You
show us?
can't let him answer. You can't talk at the same time, Ms. Stevens. Go ahead, Mr. Schiestel.
What I said was the amount of the over recovery from February is reflected in the calculation for the April charge. There are other recoveries in February, over and under, which are combined together in the balancing account, which is then reflected in the April number. And as I said, I think Ms. Ressa would be much more capable of directing you to exactly where all of them, what all of them are and where they accumulate in the April rate.
So this is basically your belief as how it operates. Okay, could you turn to?
Is that a question?
No, that's a comment. Let's turn to, could you turn to CLC Exhibit 7, Mr. Schiestel? And
Give me 1 second. We have
Yeah.
them on a big screen here or something.
it's a relief to put the big screen on.
You said exhibit 7?
CLC 7?
Okay.
And you recognize that as the New Mexico Jurisdictional Form 1 page completed by you for EPE's annual report under Rule 550, 510?
I recognize it, yes.
So, and I'm looking at this is the average monthly bill per customer. You reported as $70.54, right? For the year 2023 residentials.
Right. I'm looking at it. 1 second.
So the billing error had an impact by your own numbers of at least about 2/3 of a monthly bill. Is that right?
Well, I intentionally used usage from February 23 so that they would be on the same basis. So if you're going to use the 2240, I think you need to use the 8363 average bill that I included in my testimony.
Okay, so if you use the 86 bill, you're still at a point where you overcharged the customers by at least 50% of their bill. Is that right?
Well, no, I don't know that I agree with that. Had we, all other things equal, had the FPPCAC component been a negative 2240, the bill would have been lower, obviously, the total bill. I think that correct representation is what I included here, which was 2240 as a charge represents 27% of the total bill. And as I testified, that's not out of line with an average bill with respect to fuel and the total bill. And that was my point of that testimony.
Mr. Still, if average bills are what matter as opposed to the fuel clause, why does EPE need any fuel clause mechanism? Are you saying you'd be happy with a flat recovery of, fuel and purchase power embedded in base rates?
I don't follow your question.
I'm having difficulty understanding why you think that it matter, why you think it's so significant that the charge, given the nature of the fuel clause mechanism, I'm wondering why you think it's significant that the excess charge relative to, I'm not sure exactly what your baseline is, was within a common range of 25% or so.
Well, I think the relevance of it is that even with the billing error, we didn't end up with customer bills that were radically out of line with the say an average or a reasonable number, especially with respect to the FPPCAC. I think what we're seeing in this period is a really unusual FPPCAC being a credit in total as a result of off-system sales going back to margins, going back to customers.
So do you disagree with Mr. Provencio's direct testimony that for the city of Las Cruces, where the net plus minus effect was $120,000, that's insignificant to the customer?
No, I wouldn't say, none of my testimony is saying this is insignificant. In fact, I specifically say it was significant. I think it's important that what we did in terms of quickly addressing it is all of that off-system sales margins, in this case, that are sort of at the root, at least of the negative on the FPPCAC, were actually received by customers. I think ultimately what's important here, not to say there's nothing significant about a billing error, any billing error, is that we have a mechanism to reverse, say, a large overcollection and do it immediately. I think as Mr. Herman showed on his graph from Mr. Stradell's testimony, $8 million is not even the largest overcollection we might have realized in the past as a result of the mechanism, the FPPCAC mechanism. So I'm not saying that the billing error is insignificant. I'm simply saying in that testimony that it didn't result in customer bills that were out of line with the average, even from the perspective of this exhibit you have here.
Is it your testimony then that just now that there have been other months in which EPE in a single month over collected by more than $8 million?
No, I said that there's been balances. I believe what I said was there are balances, monthly balances over and under collections that have exceeded 8 million. And as I said earlier, I think sometimes referring to this as an overcollection might be a little unclear in the sense that what was driving these quote unquote overcollections, meaning monies that go back to ratepayers, was off-system sales margins. It wasn't necessarily discrepancies between the FPPCAC factor for cost recovery and what costs actually were. A big driver of certainly on the negative side or the overcollection side is off-system sales margins, which were never recovered from customers in the first place, right? They were generated elsewhere and then supplied to customers as a credit through the FPPCAC.
Let's get to some other things in because I'm sure my time is running short here.
Got 3 minutes.
Okay, that's it. Let's look at your rebuttal testimony at page 19, lines 11 through 13. And there you
Okay.
claim that CLC's preference is for a fuel factor similar to the formula used by EP in Texas, but that approach is opposite of the FPPC under New Mexico regulation. Where in Mr. Provencio's or Mr. Streetel's testimony do you find such a preference for the mechanism in Texas?
Well, what I say there is the preference for a fuel factor similar to Texas. And what I meant there was a limitation on the way over collections and under collections are flowed back to customers through the monthly charge.
Your Texas fuel clause factor is a pure flat factor, isn't it? Same billing charge every month?
Yes, and until it's modified. And that's why I say that this notion of retaining in your monthly balancing accounts a balance over time is more similar to Texas than New Mexico.
And on page 11, let me find it now, page 11. Oops. Page 11, question 19 on page 11 of page 11. You seem to be saying that that the informal workshops held in the summer were the sole place where the city, the county had opportunity to raise questions. Is that the gist of your testimony there?
No.
Okay, well then let me put it differently then. Earlier at the start of your testimony, you said that you do actually review at some point all of the companies' discovery responses. Were you also involved in reviewing informal discovery responses?
If you're referring to the informal discovery that took place during the multiple workshops we had prior to the filing of our amended case, I didn't attend all of those. I generally saw all the responses there, and I only quibbled with your earlier question on the soul part.
Yep.
It certainly was an opportunity for us to exchange information, and my reference there in my testimony is simply that to the extent anyone identified information that they thought would be useful for example, fuel and purchase power practices and procedures, they could have requested it there.
Okay, Ms. Stevens, that's your time.
Okay.
All right.
Thank you, Mr. Schiestel.
Thank you.
Thank you.
Ms. Souls, you had indicated that you needed 20 minutes to ask Mr. Schiestel questions. Please go ahead.
Yes, ma'am. I find at this point I have no questions for Mr. Schiestel.
Very well, Ms. Souls. Mr. Black, staff indicated they had 10 minutes reserved for questions for Mr. Schiestel. Go ahead,
Yes,
sir.
Thank you. Good morning, Mr. Schiestel.
Good morning.
Can you hear me? Good morning. See, I have 10 minutes. Let me just put this thing on. Okay. Sir, can you point me to any testimony or rebuttal testimony that discusses that the February billing error was communicated to staff?
I believe it's in Ms. Russ's testimony where she references emails and email communications with staff.
Okay. Can I direct you to EPE Exhibit 2, your rebuttal testimony at page 13?
Okay.
Lines 17 through 19.
Yes.
Can you read that, please?
Do you want me to just read the lines or the whole response?
Well, the response about a communication with staff.
Sure. The error, I'll just read 17 through 19. The error was discovered in February, communicated to staff shortly thereafter, and then reversed beginning with the April factor.
Okay, and I didn't mean to misdirect you. You were talking about the emails from other testimony from another EPE witness, and I think you are referring to an exhibit that has not been admitted yet, but is being probably offered as EPE Exhibit 4, the Reza rebuttal testimony.
That's correct. I believe it's provided in rebuttal to Mr. Provencio's direct.
Okay, I'll ask her those questions. I would like to ask, was staff's legal representative aware of the February 2023 billing input error?
That I can't say. I'm not sure. I'm sure it'll be evident from the communications, but I don't know.
Okay, did staff's counsel review the form 550 for February 2023?
So are you asking about review of the form or the communications?
The communications about the form that was going to be filed.
Right, understood. I actually, my response to I thought you were asking about legal counsel when you asked that first question. So no, I can't tell you that I know for certain who was included on that communications from staff.
Okay, I'll ask Ms. Reza. Were you made aware of any staff counsel concerns about how the error was going to be corrected?
No, I was not.
All right. And again, I'm just going to ask the obvious. Do you know if the error was an error in the FPPCAC methodology?
No, in fact, I say in my testimony in my rebuttal that it was not an error in the methodology. And I think, as I said, under cross-examination, that the factor itself in the February 550 was correct. It was shown as a negative.
All right, then how would you characterize the error?
It comes down to something as simple as coding a negative as a positive in the billing system. So it was exactly the same number, just positive instead of negative.
The city objects to this line of questioning, Madam Hearing Examiner. It sounds a lot like friendly cross to me. I'm not sure where Mr. Black is headed.
I have no further questions, Your Honor.
Friendly cross.
Okay, well, I don't know that. I don't think I'm going to overrule that objection, even though he doesn't have any more questions, just because, I mean, I think in looking at page 14 of EP Exhibit 2, where Mr. Schiestel is answering the question posed on page 13, what is your response? Which leads back to page 12, question 21. What's the significance does the city of Las Cruces place on the billing error? Bottom line is on page 14, Mr. Schiestel testified that the failing was not on the FPPCAC mechanism. It was an error originating in the EPE billing system. So that's lines 1 and 2. So I think the specific question asking what kind of error, I think is appropriate testimony, and Mr. Schiestel just clarified that it was a coding error in inputting in inputting the factor in, is that correct, Mr. Schiestel?
Yes, inputting the factor, but using the incorrect sign.
Using a negative sign and not a positive sign.
The reverse, using a positive instead. It should have been a negative.
Right.
It was shown as, it was included as billing system as a positive.
But as you further testify then at lines 3 and 4, the fuel factor in the 550 report for the February billing month was correct. So I take that to be, it had the negative in your 550, correct? Okay. All right. And Mr. Black has finished with time to spare. I have a few questions for you, Mr. Schiestel.
I would have guessed you'd have a few.
That's why this job is so much fun at times, Mr. Schiestel, is the opportunity to learn. And hopefully you didn't take too much umbrage with the first few pages of your testimony.
Not at all.
Maybe we could correct that next time. Not putting somebody else's testimony in there. But I want to know your title changed. Did you get a promotion or did they just rename you?
No, we basically moved some responsibilities around. So what changed for me was the governmental affairs group was moved into our under our general counsel on the legal side. And then I acquired two groups, resource strategy and energy efficiency. So from a regulatory perspective, nothing of my responsibilities changed.
Okay, so you're still going to be testifying and reviewing things and all the things you did before, but are you still going to have responsibility for like the FPPCAC and your other filings?
Yes.
Okay. Just for clarification purposes, and because it is still my case, I'd like you to look at since I have your rebuttal open, on page 4, you make reference at line 16 through 19 about the case that's pending. Case number 21-00064 UT. And that case, which we know was El Paso Electric's request for variance because of the costs and circumstances related to the cold weather event of February 2021. Is that correct?
Yes.
And you say in here that again, noting staff's testimony that staff doesn't think it has any bearing. But then you go on page 5 and say the resolution of that case does not implicate continuation of the mechanism. That's your testimony, sir?
Yes. So to the extent there's a determination in that case that there's any cost recovery, that would be incorporated in the FPPCAC as we proposed in the variance case. My reference there was simply that it doesn't have, the inclusion of that doesn't have any implications for say the mechanism itself.
Okay, but the ultimate decision that the commission makes in that case may have an implication on or does it on the actual amounts recovered?
Yes, it will have, it could have implications for amounts recovered if for example, if the proposed decision is adopted and EP is granted the cost recovery, our proposal is to recover those costs over a 12-month period through the FPPCAC.
Right. Okay. So going further on page 5 of that testimony, you're answering the question posed at line 12. What do the interveners recommend? And you testify that some of the, the City of Las Cruces, Doña Ana County, and Ms. Souls recommend, among other things, that the request to continue the FPPCAC be denied. Is that correct?
Yes. So the CLC DAC proposal would be to stop the mechanism in its current form and replace it with another one. And then Ms. Soul's testimony in various places, I believe, is to eliminate it entirely.
Okay. What would happen if the commission adopted that proposal to eliminate your FPPCAC? How would El Paso Electric recover its fuel and purchase powered costs?
We would need another mechanism to recover fuel and purchase power costs. My assumption is that the commission would not eliminate a mechanism for recovery of 30% of our costs without replacing it with something else.
Well, are there any specific opinions on what it should be replaced with?
Well, the Las Cruces and Doña Ana County proposed replacing it with a different version of an FPPCAC mechanism. Originally, well, I shouldn't say originally, but prior to I believe in the 2015 rate case, a good portion of our cost recovery was actually included in base rates, and so the any kind of change in that factor in base rates took place in a rate case.
Right, but I guess I have concerns about if the commission adopted that recommendation and said, okay, no more FPPCAC, how would El Paso Electric recover those costs? And,
well, as I said, we would need a different mechanism. In the short term, in that circumstance, I could see recording those costs for recovery later. But at some point, we would need to determine, the commission would need to approve a mechanism to actually recover those costs, whether it be in base rates or another fuel mechanism.
well, I know part of the El Paso Electric's testimony is that you're recommending against that.
Absolutely.
That proposal, and basically saying that kind of that it's unfair because the other IOUs have a FPPCAC, and that that it puts you at a disadvantage.
That's correct. And I think there are really two parts to that. One, FPPCAC is a mechanism and the way it works and being able to recover or at least stay current on fuel cost recovery on a month-to-month basis. In answer to your question, I think the CLC DAC proposal is really about changing the mechanism for now from what we currently have until the commission could then address maybe the actual existence or not of the FPPCAC in a subsequent base rate proceeding. So I think from that perspective, it's less problematic because it continues a recovery mechanism until a period of time when a very different mechanism, for example, go back to base rate recovery for fuel, or a portion of it could be put in place.
Do you know if any of the other electric utilities in New Mexico are considering trying to get fuel back in base rates?
No, I don't. And just for clarity, EPE wouldn't propose that either. But that is an alternative, at least one that has existed in the past. In that case, a factor was set in base rates or an amount for recovery, and the FPPCAC still existed. But at that time, with the recovery in base rates, it was really about the difference on a monthly basis between what was being recovered in that base factor and what actual costs were.
Are there any other alternatives? I mean, it's either going to be in some kind of factor or it's got to be in base rates, right? I mean, there's not any other alternative.
Well, certainly there's no alternative to putting it into a rate factor, right? In terms of getting recovery. Just to use our Texas jurisdiction as an example, it's not in base rates, but it's also not a monthly adjustable factor. It's a fixed factor that we deal with over or under collections going forward, either through changes in the factor itself, which can only occur every 4 months, or surcharges and refunds. Now we now have the ability, I'll just add, since this was in testimony and in my rebuttal, it was brought up by the City of Las Cruces and Doña County witnesses with respect to pointing to Texas. I'll just update, and I think I say in my testimony that Texas recently changed their rule with respect to fuel, and now we have the capability, if we choose to do a monthly adjusting factor more like New Mexico. And it is, at least as I sit here, my intention to explore pursuing that in Texas, because I think the New Mexico approach is better.
Why?
Well, from a utility perspective, I mean, fuel is a pass-through. So to the extent I can not accumulate large over and under collections on my balance sheet, I would prefer that. We're not in a period, at least right now, where you have huge changes or increases in fuel. I think it's better for customers. They get more contemporaneous reflection of costs on their bills. We've actually gone 12 months in Texas before returning providing a refund in fuel. Well, that has the intergenerational problem of the people who contributed to the overcollection might not get any of the money back because they've since departed. And so for those reasons, I think that just comparing the two, I prefer New Mexico's approach from both the utility perspective and the customer perspective.
Is it more advantageous to the utility to have it put in base rates?
And actually put in a fixed amount of base rates, it kind of depends on the circumstances. Generally, I'd say no. I'd rather have it changing monthly which it still does with the FPPCAC factor combined with base rates. But I would prefer to be as close as possible to a pass-through of cost to customers on a monthly basis. I think, and I even referenced this in my testimony, that one of the rationales for taking it out of base rates is it's sort of buried and not as visible to customers as it is when the full fuel charge appears on their bill as a separate line item every month.
Do you think that the amount of scrutiny that that fuel gets is more, or that the thought that some parties or individuals have, that having it in base rates, it's going to get a more critical review than currently with having the FPPCAC?
No, I actually think that it's the reverse. I think from the perspective of filing a monthly report with all the detailed calculations in the FPPCAC, filing an annual report, having these proceedings at least every 4 years, is probably more scrutiny of fuel cost and at least monthly changes in fuel costs than in a base rate proceeding. The base rate factor for fuel is basically established by the company saying, this is what I project my fuel cost to be over the next year. So it's just forecasted fuel costs. I think from a detailed scrutiny perspective, FPPCAC provides a lot more opportunity to do that. The current version.
I think it was one part of the opinion and the comment, which was adverse to the application, seemed to indicate that there's no incentive on El Paso Electric's part to, as my dad would say, have a sharp pencil when it comes to purchasing fuel or relating to fuel costs, if they can just pass it through, as opposed to actually having to justify it in a rate case.
I actually would disagree with that. I think on its face, you can make that argument. It's a pass through, so I don't care what the amount is. But I think it's important to realize, as I said earlier, it's not an insignificant component of the total bill. And really what customers look at and are affected by is their total bill. You can argue that a pass-through fuel costs that are high make it that much more difficult for the company to recover its costs, right, which are in the rest of the bill. I've seen this in the past where other charges, including fuel, are crowding out base rate recovery from a perspective of just the total bill for customers gets too large. So I think, and I think our performance in terms of off-system sales and our efforts to maximize the use of our facilities, our generation to the extent possible to both provide reliable service and generate margins for customers has been pretty good, very good in the end of 22.
Before I move off this page, I want to ask this question. And I'm still looking at page 5, and you've made reference to the proposals of the city of Las Cruces and Doña Ana County. And you make reference to EPE's next general rate case. Do you know when that's going to be?
Not with great certainty, but I would predict it would be next year.
Also, a couple of things I want to clarify before I got too far away that relate to your the difference between your application and your amended application? And in your amended application, you have item 16, which essentially, when you compare that to the original application, you had 3 witnesses, but you have 4 witnesses that were filed, that filed testimony in your amended application. Is that correct?
Yes, I believe that's correct.
And
There are 4.
yeah, and also Mr. Gonzalez originally filed testimony, and Mr. Dominguez.
So Mr. Gonzalez originally filed testimony.
Okay.
That portion of our application was essentially taken over by Mr. Martinez.
Okay.
Mr. Dominguez was added
Okay.
when in the amended application, when we added a lot, the discussion on the WEIM and the effect on FPPCAC. That wasn't in the original application.
Okay. And then also in the original application, in the wherefore paragraph at the end of page 6, and this is the part where you're asking for what you want again. You're asking that the FPPCAC to continue and the commission to issue a final order granting the continuation of the FPPCAC, reconciling the costs for the period of January 2017 through December 31, 2021, and then any other relief the commission may deem necessary for the FPPCAC. You don't have the reconciliation statement in your wherefore paragraph on page 6 of your amended application, do you?
No.
Why?
We did not include that in the amended application. I discussed that in my direct. I apologize. I'm looking for it. But generally, the why was the determination, in one aspect of it was the determination in the Supreme Court decision on the appeal of our rate case. So in our rate case, we had filed for reconciliation of fuel costs and revenues. And it had been approved by the hearing examiner, but denied by the commission, is my recollection. That was one of the aspects of the appeal that was granted by the Supreme Court. And so I believe in the subsequent commission determinations, it was that reconciliation was approved from the rate case. The decision then following that was, it made more sense to include future requests for reconciliation in rate cases as opposed to the continuation proceedings. So we took it out in the amended application.
But historically, has that not been part of your continuation request?
I believe we've done both. I believe we've included reconciliations in both rate cases and continuation filings. That was another thing. There was some overlap between, my recollection is there was some overlap between the reconciliation that was granted after the appeal and the continuation period. But it was my feeling that seemed to be a recognition by or approval by the commission in a rate case, and maybe we would pursue that and in rate cases. And given the expectation, at least, that we had a rate case coming, we thought to simplify this application to the extent possible and do that in the next rate case.
Okay, in looking at your direct testimony, El Paso Electric number 1, page 14, you are talking about when the current FPPCAC was approved, and you reference case number 18-00006, and that approved reconciliation from January 1, 2015 through December 31st, 2016.
Correct.
So it only reconciled for a period of 1 year?
Well, 2 years, all of 2015 and 2016.
Oh, okay.
And then subsequently, in the rate case, the period was 2017 through 2019, I believe.
Okay, and you're referring, when you say the rate case, you're talking about case number 20-00104 UT?
Yes.
Okay, but when you're referring to the rate case in your testimony on page 14, question 16, the 2015 rate case, that's case number 15-00127 UT, is that correct?
Yes, I believe that's right. I was gonna jump in, but I wanted to see if you, because I wasn't sure either, but I believe it's 127. Yes.
Okay, all right. Well, you didn't put what rate case it was, so I just wanted to clarify that. Okay, so when you talk about the last rate case, the 104 one, on page 16 of your testimony, well, I'm going to back up to page 15. So you indicate in your testimony on page 15 that the 2017 RPS case affected the FPPCAC because basically the RPS cost, which had been recovered through the FPPCAC, but with a new rider going into effect in January of 2018, those costs were removed from the FPPCAC, correct?
That's correct.
So that's a big change from last time. And last time, I mean your last FPPCAC continuation case, correct?
Yes. So the timing is interesting here, I think, but the new rider became effective 1st of 2018.
Yes.
And the continuation filing was made the 1st February 2018. And since it's backward looking, that would have been a period of time where all of the renewable resources were still recovered in the FPPCAC, and then going forward from that, they were split between the rider and the mechanism. So that happened in this continuation filing with respect to the removal.
Okay. And then on page 16, you're talking about the impact of your last rate case final order. And during that final order, you say on page 16, lines 8 through 9, EPE's proposed change in the monthly FPPCAC mechanism to estimate monthly cost based on a rolling 12-month average of actual cost. That was approved, correct?
Yes, in the rate case, it was approved.
Okay. And that didn't change with the appeal, right?
It did not. We had originally made that proposal to a degree. We had originally offered this proposal, the 12-month rolling average, in the prior continuation file. So the 18406. We had originally made that proposal at some point in the proceeding, and it was determined that it made sense to propose it in the next rate case, which we did, the 2020 case, and then it was adopted there.
Okay. And then also impacting the FPPCAC was the well, I'm not going to agree with your characterization that the commission eliminated it. I think if I recall correctly, since we dealt with this in 210064, the variance case, El Paso Electric had proposed a new proxy pricing or a new pricing mechanism for Palo Verde 3, and that was not adopted by the commission, resulting in Palo Verde 3 energy not being allocated to New Mexico as a result of that rate case decision. Is that correct?
I'd say yes. I can agree with that.
Okay. And so that's a change, right?
It is a change in the
Since last time.
That's reflected in the FPPCAC, yes.
Okay. But when you keep referencing in the testimonies, the cost of power from Palo Verde, is non-Palo Verde 3 energy being allocated to New Mexico?
Yes. So if your question is Palo Verde units 1 and 2 serve New Mexico, yes. And the cost of nuclear fuel is recovered to the FPPCAC.
Okay. So we have several of those items that that have caused a change. And then I think additionally, there was an agreement that since the rate case, and I don't recall the timing specifically, but the other issue which we have information on is the Western energy imbalance market. And that's something that's occurred since the last FPPCAC, correct?
Yes, and that was a big part of extending this time frame and having the amended application was to pull in WEIM data. The timing of our original filing and our joining the EIM were really close together. We joined just after, so we had essentially no information within the original application. So that was one of the, I think, stated concerns of parties with respect to what was going to be included in the FPPCAC, and we agreed that we should abate the proceeding. I think it was abated for at least for a while, and so that that information could be included along with 2022 data.
Okay, and then the reference for my my prior question to you regarding the elimination of the FPPCAC, if you look at your testimony in El Paso Electric, Exhibit 1 at page 19, where you're saying it should be continued for 2 reasons. That's at beginning at line 7, and you say the FPPCAC should not be eliminated or conditioned if it would place EPE at a competitive disadvantage. And I guess a competitive disadvantage as to who?
So certainly it has an effect on the company's financial position if it could have an effect on the financial position. The reference there is really now more than ever, I think we all utilities compete for commercial customers. And so to the extent you have and this obviously is speculation, but to the extent you have a rate component that causes your rates, let's say, to be less attractive than other utilities from a commercial customer's perspective when they're looking at service territories, it can have that competitive disadvantage.
Well, I was just wondering if you were referring to some kind of disadvantage when you were trying to purchase fuel. And I was not seeing how that would work.
No, I don't think that would be a source of a disadvantage or advantage. It's certainly, I'm just again hypothesizing about what other mechanisms might look like, but it can certainly raise some credit issues. It certainly has cash flow issues, and so there are those financial disadvantages that can occur based on the say recovery mechanism for fuel.
Sir, your testimony on page 22, you're answering the question, are fuel and purchase power costs a significant percentage of EPE's revenue requirement? You're answering yes, beginning on line 3. And then line 4, you says, as can be seen in your JS Exhibit 1, the fuel and purchase power costs represent approximately 29.6% of EPE's total New Mexico jurisdictional revenues, base plus fuel, for the continuation period of January 1st, 2017 through December 30th, 2022. So a 5-year period, right?
You're gonna make me count on my fingers. January. It's actually 6.
6-year period. Good thing you had another hand to go there to count those up. So yes, for the period of 6 years, in the next sentence, the monthly percentages varied significantly from a low of 0.5% to a high of 45.2%, correct?
Right. And those would be monthly percentages. The reference to the highs and the lows. And that's shown on JS1.
Right. So in that particular example, you're talking about percentage of revenue, correct?
Correct. Fuel revenues as a percentage of total revenue.
In both percentage examples.
Yes.
But then on page 23 of your testimony, looking at your testimony on your JS-4 exhibit, you say beginning on line 13, exhibit JS-4 shows that on average during the continuation period. Now, when we say continuation period, are we looking back at this same 6-year continuation period?
Yes.
Of January? Okay, so we're not looking at the 4-year. We're looking at this 6-year. Okay, so we're looking at the end of 22. The total cost of natural gas-fired generation and power purchases comprised 89.9% of EPE's annual total fuel and purchase power costs, correct?
Correct.
Okay, so that's a cost. That's not a percentage of revenue.
Well, it's a percent, right? It's a percentage of cost just looking at our total fuel and purchase power costs. So the first one looked at fuel and purchase power plus base and how much did fuel represent of that. This one looks at just the fuel and purchase power cost. How much is natural gas?
Right.
Natural gas and purchase power, sorry.
Okay. And then on page 24, question 27, does EPE expect the fluctuating cost trend will continue? And you answer yes. And then at line 5, beginning on line 5, you say this trend will continue because natural gas and purchase power, the cost of which is highly correlated to natural gas prices, in the energy markets will continue to reflect significant price volatility. That's your testimony?
Yes.
And I actually had a question similar to Ms. Stevens' question, I think. And that was, since you're projecting this trend to continue, my question was, however, if the requirement in the ETA is to eliminate carbon resources and use more renewables, won't the trend change in the future?
It will, the gas price trend may stay exactly the same, right? But the proportion of resources that are natural gas burning in our case will decline. So from that perspective, it's that combined effect on fuel costs may very well be muted as you add more and more renewables, but I'm not going to speculate on exactly how cost of renewables in the future will be reflected in our recovery factors.
Okay, so I just need to confine the trend then in your testimony to natural gas prices,
yes.
not to the trend in the variability of fuel costs as it relates to the FPPCAC.
Right, exactly. Okay. So the variability of the FPPCAC factor itself.
Okay, so just to hopefully clear up the reconciliation issue on page 26 and 27, you state in your testimony, beginning at line 4 on page 27, November 30th, 2023, the commission issued its order on remand in case number 20-00104 UT, adopting staff's recommendation to grant EPE's request for a reconciliation of EPE's FPPCAC for the years 2017 through 2019. EPE considers reconciliation of its FPPCAC through December 31st, 2019 to have been resolved. That's your testimony, sir?
Yes.
Did EPE appeal this case again?
Yes, I believe so. I believe we appealed specific to prior, I don't know, what's the best way to say this? So the approvals in the appeal by the Supreme Court changed our rates going forward from essentially the date of the remand, if I'm not mistaken. But it didn't address the period from the date of the order in that case up to the remand date. And I believe the appeal of the case addresses that period of time. So it doesn't appeal the rates going forward. It simply appeals the treatment of the revenues that we would have realized had the rates been in effect at the original order date.
So for my purposes, then what you're saying is that, yeah, there's a second appeal, but you're claiming that it's a retroactive rate making issue. It's not, or an effective time going when the rate should be effective issue. You're saying that as far as you know, the issue concerning the reconciliation period is not currently on appeal.
That's correct.
So okay, let's see if I can do this. Can you see that screen, Mr. Schiestel?
Yes.
This is, I will represent to you a document that I got out of InfoShare, and this relates to 18-00006, your last fuel continuation clause case.
Yes.
And this was an errata notice that hearing examiner Sundheim issued. And she was correcting some things and items 1 and 2, but then somehow she added an attachment, and that's what I want to ask you about. This attachment C, the reconciliation schedules for years 2015 through 2016 that were filed as Ms. Borden's exhibits 1 and 2. You see those?
Yes.
are those the same types of exhibits that which witness would have? Which
These-
El Paso Electric witness would have these?
Miss Ressa has this in her direct testimony.
Okay.
Now they're not presented as reconciliation statements. They're presented as cost and revenue statements as required by the rule, but the same information is provided by Ms. Ressa.
Okay. Also, with reference to your direct testimony, and I have to compliment you for your use of very few footnotes. Mr. Schiestel, unfortunately, I've gone over the cliff. And I've gone from not believing they're appropriate to, I don't know, I think I had close to 400 in my last recommendation. And I just wanted to clarify your footnote 8 on page 20, and you're talking about the cost recovery for the RPS, how it had been moved to a rider mechanism. And so my question was, is this the only fuel recovery that's outside of the FPPCAC?
I believe so. I'm just thinking it for a second. I can't think of any place else that would be the case. And specifically the RPS resources or the renewable resource costs that are reflected in the RPS are the ones that are dedicated to New Mexico and for compliance for the REA. So there are some renewable resource costs included in the FPPCAC, but we distinguish between renewable facilities that are procured and serve New Mexico, serve both jurisdictions. We call them system resources that are procured to serve load. And then we identify with the ones in the RPS rider to be those specifically for RPS compliance.
Okay. And that sort of coincides with my question on page 10 of your rebuttal testimony, EPE Exhibit 2. The question begins on page 9, and it has to do with whether or not the costs are that are being collected through the FPPCAC are the ones that are actually expended, and you say yes on page 10. Itemized monthly revenue and expense statements demonstrates all fuel and purchase power costs collected revenues to match the cost, and the ending balance shows the difference for the continuation period. I just wanted to clarify for the record, page 12, when you're talking about the billing input error, you testify on pit lines 12 and 13. New Mexico, we got two customers there, were charged this amount rather than credited it. So this only happened in your New Mexico jurisdiction. This did not affect your Texas jurisdiction?
That's correct.
You say on page 13, again, with regard to the billing error, the issue resulted from several factors. Other than the inputting of the plus or minus in the billing code, what other factors occurred that you're referencing here?
Well, certainly the first would be the incorrect imputing of the error. The second would be not catching it before it went into the billing system. It's that second part that we've endeavored to make sure we have plenty of review processes in place to identify those types of things. But as I said, I think that's the only thing, that is what conspired to create that, positive instead of a negative. The magnitude of the difference, as I said earlier, is a result of the size of the potential
Right.
credit. But basically, the billing error occurred because one, the mistake was made, and then two, it wasn't caught by review.
Okay. And you're saying now, since as a result of this, that you do have review processes in place on inputting coding items into your billing system?
Yes, I would say in two ways. I know that from the perspective of our testing, so we do testing of billing anytime rate changes are made. That's a little less the case, or it has been traditionally with the FPPCAC, just because it happens every month. But I believe not only do we look at this on the testing side, where you're independently calculating what a bill should look like and then what it looks like coming out of the billing system before you go into production, but also just obviously we're very well aware now of the potential for this and review accordingly.
Well, I think I've already asked you about the ebb and flow of the mechanism. So let me just check, Mr. Schiestel. Thank you, sir. That's all the questions that I have for you. Appreciate your time. Mr. Wexler, are you going to have any redirect?
I have no redirect, Madam Hearing Examiner.
Very well. has anyone got any questions based on my questions for Mr. Schiestel? We'll start back at the top. Mr. Herman,
Yes, I do have one question.
go ahead,
Or
sir.
One line of questions. Good afternoon, Mr. Cecil. I want to go back to the hearing examiner's questions about,
Your audio's kind of fuzzy there.
I'm sorry, I'll stop pontificating and just get to the point. Mr. Cecil, do you think it's a benefit to the company to have a fuel clause? Is that the company's position?
I think it's a financial benefit in the sense that since these are costs that we incur to the ability that whether they're higher or lower, the ability to pass them through to customers as immediately as possible is financially, I hesitate to say beneficial because it doesn't necessarily provide a financial benefit so much as a void of financial difficulties from, say, waiting a long time to recover costs or even holding revenues for a long period of time before they're returned to customers.
Just thinking out loud, as we move to a, let's say, carbon-free resource world, do you think it makes sense to keep having fuel clauses?
I believe so. I think it will continue to make sense, even if you were to imagine a circumstance where it's substantially non-fuel resources like solar, for example, right? Which don't necessarily have a fuel cost. They certainly have a cost, but not fuel. I still think it makes sense to have a separate charge for, say, this variable energy costs that you have, even coming out of renewable facilities. If for no other reason, it's clear to customers what those costs are.
And do you think it might make sense to separate fuel from purchase power in the rider?
That's a more complicated one, I think, but
this was just a thought that occurred to me as we
well, I only hesitate from the perspective of one of my sort of going in assumptions for a lot of these type of questions is that customers are more comfortable with fewer rate factors than a whole lot of rate factors, and we end up with rate factor inflation as we go through cases and identify specific things. I think it's probably better to have them all combine into a rate factor for fuel purposes, maybe call it variable energy costs. But we get into too much separation, I think it becomes a complication. I think it would be, frankly, in the company's maybe interest to be able to point to a big credit for off-system sales margins and say, hey, look what we did for you. But we combine all those things together, and I think that's, at the end, is probably simpler for customers.
Mr. Herman, anything further?
No. Thank you, Mr. Schiestel.
Thank you. Any questions based on my questions, Ms. Stevens?
I have one that's probably more for as much for Mr. Wexler as for yourself. But Mr. Schiestel, you and the hearing examiner talked about a number of prior cases and court orders. Do you agree that the orders of the Commission and the New Mexico Supreme Court speak for themselves, and your descriptions of them are relatively unimportant?
They certainly speak for themselves, yes.
Thank you.
Okay. Is that it, Ms. Stevens?
Yes.
Very well. Ms. Souls, any questions based on my questions?
Yes, ma'am, just a couple.
Okay, go ahead.
Hello, Mr. Gisel.
Hello.
You and the hearing examiner had some conversation about reconciliation and its long convoluted path to where we are today. But I'm interested in what you are using as a definition. What does reconciliation mean?
I don't have it in front of me. I thought that the description from the commission in deciding that essentially approving the reconciliation following the reband was pretty good. I would summarize it as agreeing that the revenues recovered by the utility for fuel are equal to the costs of fuel.
And may I clarify, when you say fuel, do you mean the many elements within the FPPCAC?
I mean, right. I mean, everything reflected in the FPPCAC, and talking about reconciliation in this context, it's specific to the FPPCAC.
Thank you. And is it your position that from EPE's perspective, that the revenues and costs of the FPPCAC factors do in fact match?
Do in fact,
I'm sorry, I don't have much. Do in fact match?
thank you.
With the caveat that there's also the balancing account component. So over some period of time, the concept of reconciliation is that this is the amount of revenue that was actually recovered. These are the costs prudently incurred. This is the difference in the balancing account, and all of those three things together should net out to zero. Or
and when you say prudently incurred in response to my question, EPE believes they are prudently incurred. Is that correct?
When we present them for reconciliation, that's correct. When reconciliation is approved, it is in agreement with EP that the costs that were recovered were prudently incurred.
Thank you. One other thing, you have a couple of times referenced the margins generated by El Paso Electric's off-system sales activities. Do you recall that?
Yes.
And what exactly is the margin that you're referring to?
The difference between in a sales, since it's in a sales context, the difference between the cost of the sale and the revenue generated by the sale is the margin.
And the revenue, am I correct, that comes from an actual transaction that is booked?
Yes, that's my understanding.
And where does the value for a cost come from?
EPE determines the cost associated with the power provided in the sale.
It is a calculation that EPE conducts, is that correct?
It's a determination by EPE, yes.
Very well. Thank you. I have no further questions.
Thank you, Ms. Souls. Mr. Black, any questions based on my questions?
Thank you, Your Honor. No.
Very well. Thank you, sir. Mr. Schiestel, thank you. I'm sure you'll be tuned in in case we have to come back to you. Okay. Thank you so much. Your excuse, sir. We are going to break for lunch. Hopefully an hour is going to be enough. And I've got 12:31, so we'll come back at 1:31.
Madam Hearing, I'm sorry to interrupt. Staff doesn't need 10 minutes for a non-existent witness, Gonzalez, and we'll throw that time out. And then Mr. Trethaway, we're not going to examine him. I'm sorry to interrupt.
Okay. Okay. All right, very well. Now we're at 12:32. We'll come back at 1:32, and I believe El Paso Electric will present, is Ms. Reza?
That's correct, Your Honor. The only, if you and the parties are willing, we would prefer to change the order so that after Ms. Riza comes Mr. Bustillos. And the reason is, as we were going through this more yesterday, we recognized that it would be easier to understand Mr. Bustillos's testimony first. It logically comes first, and that way there would be less references to witnesses that have already gone. In other words, it may be that Mr. Bustillos needs to refer testimony to Mr. Martinez.
Okay.
Madam Hearing Examiner, the city objects to that. We were told, first of all, we disagree, but we've prepared our cross-examination in expectation that Mr. Martinez, as he does in his testimony and in discovery responses, will be deferring questions to Mr. Bustillos, not the other way around. I don't think that it's fair for the company to change what they've proposed. And again, the gist of the testimony seems to run the other way.
Yeah, we don't have that strong an opinion. I think
Okay.
it's usual that the city is trying to tell us how to put on our case, but we're willing to stick with what we said.
Okay, and I'll just go by that in the pre-hearing memos that I required to be filed last week. And then again at the pre-hearing, there weren't any changes. So unless there's some type of emergency, let's stick with what we have, and we'll go from there. Okay, now we're at 12:34. So let's come back at 1:35 and we'll hear from Ms. Risa. Thank you all. Remember, the YouTube stays on, so please mute and do whatever is accordingly. Thank you very much. I'll see you at 1:35.
Examiner Hurst. Before we go back on the record, can I ask permission to take my jacket off? I can't hear you, but I'm hoping that was permission granted. The swan cooler is not as effective as I'd like.
That was, it looks like it's already off. And absolutely. Absolutely, Mr. Herman, very reminiscent of old school politeness and manners that used to be extended during hearings, and very reminiscent of someone we lost recently, Mr. Templeman.
Oh, really?
Sorry.
I didn't know that.
He was a gentleman,
Gentlemen.
very much a gentleman in the proceedings that I was fortunate to work with Bill, primarily telecom proceedings. So are we? Pardon me, sir?
I couldn't hear you. Did you say Mr. Tupler?
Mr. Templeman.
Oh, Mr. Templeman. Bill Templeman?
Yeah.
Huh.
Are we going to have anything that we need to address? And I don't know why you're echoey. There's no chance you have YouTube on, is there?
No, but I'll switch to my headset.
Mr. Herman, you're breaking up, really. I mean, I'm getting it, but it's hacky, to use a highly technical phrase.
Let me switch.
Does anybody have an
Unfortunately-
opinion on whether if he signed out altogether and came back in, he might have a better chance? I'm the least technical person here, but I mean, that's the old like reboot your computer theory.
I don't know, but obviously if you can switch to your headphones or something else that's going to give us an unmuted or not unmuted, but an
Unfortunately,
bisected audio, that'd be great. All right, how are we doing, Mr. Lee? Are we ready to sally forth?
Yes, Judge.
Speaking as a old term, an old equestrian term. Very well, let's go back on the record then. We are returning from our luncheon recess, and we'll continue with the presentation of El Paso Electric's witness. Mr. Wexler, you have another witness.
We do. We call Julissa Riza.
And looking at the screen, we'll have Victor Martinez 2, the sequel. Good afternoon, Ms. Riza. Welcome.
Yep.
You got to unmute yourself.
Muted.
Okay,
There you go.
my apologies. Good afternoon, everybody.
Good afternoon. Mr. Lee, would you please swear in the court, or the court reporter? Would you please swear in yourself? Would you please swear in Ms. Riza?
Ms. Reza, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter and opinion should be the truth, the whole truth, nothing but the truth?
Yes, sir.
Thank
Go
you,
ahead,
ma'am.
Mr. Wexler. Thank you, sir. Go ahead, Mr. Wexler.
Thank you. Can you please state your name and then spell it for the record? We're having trouble hearing you again.
Hey, can you hear me now? Yes.
Yes.
All right. My name is Julissa Reza, and you spell it Julissa. middle initial I, last name is Reza.
Do you have before you what's been previously marked as EPE Exhibit number 3?
Yes, I do.
And that has a title of Direct Testimony of Julissa I. Reza on behalf of El Paso Electric Company with the date of December 18th, 2023. Was that direct testimony prepared by you or under your direct supervision?
Yes, it was.
If you look on the second page of EPE Exhibit 3, there's 2 exhibits. The first is JIR 1, which are the monthly revenue and expense statements for 2017 through 2022. And the second is JIR 2, which is EPE's annual 550 Form 1 filings for the same period. Did you collect those exhibits, or were they collected under your supervision?
Yes, they were.
And are you familiar with all of those documents?
Yes, I am.
Do you have any corrections to your direct testimony?
Yes, I do have a small correction on page 3, line 6, in reference to Rule 572.15, should read parent F parent for subpart F.
And I
Okay.
believe that
I missed that. Line 6, it should have,
On the subpart for the rule, ma'am, it reads Rule 572.15, and it should be parent F parent instead of E.
okay,
is that the only correction?
Yes,
With that correction, is the testimony in EPE Exhibit number 3 true and correct to the best of your knowledge?
yes, it is.
If you were asked the same questions today under oath, would you give the same answers that are contained in EPE Exhibit number 3?
Yes, I would.
At this time, we offer EPE Exhibit number 3.
and Mr. Wexler, did the Dropbox version have the correction?
I believe it does.
Very well. Ms. Reza, the information contained in your exhibits 1 and 2, is that information true and correct to the best of your knowledge?
Yes, it is.
Very well. Any objection to what's been identified as Ms. Reza's direct testimony as corrected by her here today and identified as El Paso Exhibit 3? Hearing no objection, Ms. Reza's testimony is admitted. Mr. Wexler?
Ms. Reza, do you have before you what's been previously marked as EPE Exhibit 4?
Yes, I do.
And that is entitled Rebuttal Testimony of Julissa I. Reza on behalf of El Paso Electric Company, this time dated May 31st, 2024. Was that rebuttal testimony prepared by you or under your direct supervision?
Yes, it was.
And again, if you look to the second page, you can see a list of 4 rebuttal exhibits. Were those rebuttal exhibits prepared by you or collected by you?
Yes, they were.
And are you familiar with each and every one of those rebuttal exhibits?
Yes, I am.
Are they true and correct to the best of your knowledge?
Yes, they are.
Do you have any corrections to your rebuttal testimony?
I do not. I do not have any corrections.
Is the rebuttal testimony, along with the exhibits, true and accurate to the best of your knowledge?
Yes, it is.
If you were asked the same questions that are posed in your rebuttal testimony today under oath, would you give the same answers?
Yes, I would.
We offer EPE Exhibit number 4.
Any objection to what's been identified as El Paso Electric Exhibit number 4, Ms. Reza's rebuttal testimony?
Madam Hearing Examiner, the city
Ms.
would like,
Stevens?
the city would like to voir dire Ms. Reza on the exhibits and the related testimony, particularly JIR 1R, which is exhibit AH, EP exhibit H5 from the last general rate case. I do not know that the standard that seems to be applied here is that she collected the evidence from prior cases is sufficient given the nature of her testimony on that exhibit.
So you have a potential objection to one of her exhibits?
Yes, and the testimony around it.
Okay, go ahead.
Okay, good afternoon, Ms. Reza. I'm Anastasia Stevens. I represent the city of Las Cruces, and I do believe we've been on Teams meetings but never met face to face before. Is that correct? Such as it is.
Yes, ma'am, that is correct. Nice to meet
Okay.
you.
And this is your first time testifying, I understand. So congratulations for being here.
Thank you.
So I'd like, so that's the first question I had about your background. You haven't testified before. Have you testified before the Public Utility Commission of Texas or any other regulatory body or court?
No, ma'am, I have not. This is my first time.
And turning to page 1 to 2 of your direct testimony. Oops, actually managed to lose again.
Okay, I thought you had a potential objection to her
Yeah, I
rebuttal
haven't, I want
testimony.
to know, okay, I could go.
Okay, so let's ask
Okay.
those questions,
Okay.
please.
Your exhibit JIR1R is an exhibit from the last general rate case, is it not?
Yes, ma'am.
And did you
Yes,
have
ma'am, it
any
is.
part, in preparing that exhibit back in 2020?
No, I did not. But I did direct, was involved in getting it into our exhibit for this case.
And what do you mean you were involved in getting it into your exhibit, into the exhibits for this case?
I identified the exhibit that we wanted to include in our case.
And have you verified the information in that exhibit? A lot of numbers.
Yeah, I have looked at the information for spot checked a couple of line items.
When you spot checked a couple of line items, do they go to the contention that you make in your rebuttal testimony that the manner in which EPE averages the monthly fuel cost factor, develops the average 12 months rolling average. Did you verify those portions of the exhibit exhibit JIR1R, also AH5?
Yes, ma'am. I spot checked, if I'm understanding you correctly, I spot checked the calculation for the 12-month factor on a couple of the line items.
Okay, so you'll be able to explain, will you be able to explain to me when we get into your actual cross-examination how that calculation is done based on the numbers in that exhibit?
Yes, ma'am.
Okay, well then I withdraw my objection, Madam Hearing Examiner.
Very well. Any objection to what's been identified as El Paso Electric Exhibit 4, Ms. Reza's rebuttal testimony? I would just note, Ms. Reza, were you listening on the YouTube this morning?
Yes, ma'am, I was.
And did you hear me read what the commission rule on rebuttal testimony was?
Yes, ma'am, I did.
And that rebuttal testimony is supposed to be testimony, evidence which tends to explain, counteract, repel, or disprove evidence?
Yes, ma'am.
I would point out in page 20 of your testimony in EPE Exhibit 4, question 29 and the answer thereafter, you're commenting on staff testimony. I don't believe necessarily that comports with rebuttal testimony, and I would just caution you for your future testimonies that you keep in mind exactly what rebuttal testimony is supposed to be. And And with that caution, EPE Exhibit 4 is admitted.
Thank you,
Mr.
Madam.
Wexler,
At this point, we tender Ms. Reza for cross-examination.
thank you. According to my handy dandy chart, I believe, Mr. Herman, that you reserved 25 minutes for Miss Reza. So if you'd like to
Yeah.
go ahead, sir.
Yeah, before I start, Mr. Leek, is my sound coming in better?
Yes, sir.
Yes.
Okay. Good. Sorry, I just got thrown by your name being Victor Martinez. Good afternoon, Miss Reza. My name is Keith Herman. I'm counsel for Doña Ana County. And as my internet connection may go out on me at any given moment, I'll dispel the pleasantries and just ask you to, do you have available to you what's been labeled as Doña Ana County DAC Exhibit number 1?
I do, sir. Let me just get there, please, if you give me a minute.
Sure.
Mr. Herman, tell me again, please, which exhibit that is.
DAC Exhibit 1 is, and not to be confused with DAC CLC exhibit, this is Doña Ana County's exhibit, is
Very well.
El Paso Electric's response to our 4th set of interrogatories and requests for production.
Is that it?
And it is, as we're going to be bouncing back and forth between a couple different pages, I think it might be helpful, as we'll pull up, is Yulissa Reza exhibits JIR 2, a couple pages of that I'll be referencing this throughout. So I'll first start by asking Ms. Reza to identify this exhibit.
Yes, sir. I see CLC 4-1.
And if you scroll to page 4 of 8, that would be request for admission 4-2, correct?
Yes, sir.
And you sponsored both of the company's responses to these questions?
Yes, sir, I did.
And if I asked you these questions again today, would your answers remain the same?
Yes, sir.
At this time, I will move to admit Exhibit DAC 1.
Is it the entire exhibit or is it simply 4-2?
It is 4-1, 4-2, and at the very end is Miss Reza's affirmation or declaration.
Ms. Rosa, to the best of your knowledge, is this your complete answer to these 2 interrogatories?
Yes, ma'am, it is.
Any objection to what's been identified as DAC Exhibit 1, El Paso Electric's responses to interrogatories DAC-4-1 and DAC 4-2. Hearing no objection, DAC 1 is admitted. Mr. Herman?
Thank you. Now, Ms. Reza, I would like to direct you to, let me make sure I pull up my exact reference.
Do you still
believe
need it up there?
No, we do not need that up, although
Okay.
I will come back to it. But I wanted to direct her to her rebuttal testimony at pages 9 and 10. So starting at page 9, line 19, you discuss EPE's desire to continue its fuel clause mechanism with its rolling 12-month average methodology, correct?
I'm sorry, did you hear that?
I did not hear that, no.
My apologies. Yes, that is correct.
And then in response to that question on page 10, starting at line 1, you say that this is compliant with the do you say the cost-based methodology in case 20-104?
It's consistent with the methodology, yes, sir, in that case.
And now in preparing your rebuttal testimony, you reviewed the direct testimony of county city witness James Streedell, correct?
Yes, sir, I did read that testimony.
Do you recall his testimony on the difference between cost weighted average and price weighted average?
Yes, sir, I remember reading it. Don't remember all the details.
Okay, that's all I need right there. This is where we're going to go into your direct testimony. And I apologize for the convoluted reference, but we are going to go to Exhibit JIR2, page 307 of 390. And if you're following on your computer with the PDF copy, that is PDF page 334.
Okay, yes, sir.
So referring to DAC CL, or I'm sorry, Doña Ana County Exhibit 1, we asked you some questions about this exhibit, correct?
Yes.
Now, without running through all of the sub-questions of 4-1, would it be fair to say that question B, we discuss the actual amount of fuel and purchase power costs?
Yes, sir. It is the sum of the New Mexico fuel and purchase power costs.
And then that amount is 44,555,715.
Yes, it is the number that I'm seeing on the exhibit 41C.
Yes. And then in question H, we have the exact calculation of EPE's calculated rolling 12-month average times the number of New Mexico kilowatt hours, correct?
Yes, that is correct.
And then in question I, we just simply ask you to make the conclusion that those two numbers do not equate, correct?
Yes, sir, that's correct.
And the difference there is about approximately 200,000.
Yes, that appears to be correct.
And that was for December of 21.
Yes.
And then
Wait a minute, wait. That question I?
Yes.
That says it's for the months of January through December 2021.
Yes, my apologies, ma'am. Yes, it is for the year of 2021. So January through December 2021.
Okay. Go ahead.
Thank you for that. And without repeating all those questions, for Doña Ana County request 4.2, which is page 4 of Doña Ana County Exhibit 1, we did that same exercise, but for 2022, correct?
Yes, for the entire year of 2022. That's correct.
And for those of you following along on your computers, that is PDF page 414. And in question 4-2I, as in Ichabod, the difference there in the actual versus the calculated factor was much higher. It was about $3 million, correct?
Yes, that is correct.
Thank you. So is the company's position that there is still no difference between a cost weighted average versus a price weighted average?
My position is that we are calculating the 12-month rolling average in accordance with the proposal in the 2020 rate case.
In preparing your testimony, did you review Rule 550?
Yes, I did.
Are you aware of the objective that the fuel and purchase power cost clause would be used to recoup the amount actually expended for fuel and purchase power costs?
Yes, I am.
So would you agree that a method that brings us closer to actuals would be more in line with the objectives of the fuel purchase power clause rule?
I would say that there are various ways of calculating this 12-month rolling average, and go back to the fact that we are following the methodology that was proposed in our rate case and was approved by the commission.
And do you know if that method was with specific regard to price or cost?
Was specific to the calculation that we recorded. That was more price. But it is as well based on the average, on the actual costs and coming up with a per unit rate.
I'm sorry, could you repeat that? You want to get it close to actual costs, you said?
Yeah, no, I said that we do our calculation utilizing the actual fuel and purchase power costs in determining the rate per kWh that we utilize.
Okay, no further questions. That was all I had for this witness. Thank you very much.
Thank you.
Thank you, Mr. Herman. Ms. Stevens, I believe that you allocated 50 minutes for this witness.
Yes, ma'am.
Okay, please go ahead.
Hello again, Ms. Reza. I will get back to what Mr. Herman was asking about, but let's look at page 5 to 6 of your direct testimony, please.
Okay, just 1 minute.
Yeah.
Okay.
Okay.
Okay, I'm there.
Oh, wait, I'm in the wrong place. Oh, it's, no, pardon me. It's not 5 to 6. It's 5 to 6 of my notes. Okay, let's try this, start this over again. On page 10 of your direct testimony.
Yes, ma'am.
You've got a graph on the bottom of that
I do.
page. And this is supposed to show that the use of the 12-month rolling average factor has reduced variability in the build rates. Is that right?
Yes, ma'am. Compared to the prior methodology that we had that consisted of just 1 month of fuel costs from 2 months prior.
And first off, let me ask you, in light of some of the legal arguments that occurred earlier this morning, your graph here, Carrie, goes from August 2021 to August 2023, correct?
Yes, it does.
Yeah. So you used August data to try to demonstrate the preferability of the current methodology, is that right?
We included additional data to provide more data points. Yes.
Okay. And would you agree that up until, well, really up until January or February 2023, the lines are pretty close together?
Yes, and they're like really close together through May of 2022.
But looking at February, is that little peak there? I have to stop myself. I'm putting the cursor on my screen. It's not helping anybody. But that little in the blue line, the sharp blip there over February, the little blip there, medium-sized blip there over on February 2023. Does that reflect the company's billing error and the fact that it actually billed a positive 3.2 cents per kilowatt hour rather than dropping down to a negative 3.2 cents per kilowatt hour?
On the blue one is the one you are referring to, correct?
Right, the blue line.
I'd have to go back and look at the details.
Well, would you like to look at the details? I think we should look at the details. So would you turn to, now I'm trying to notice, the February 2023 billing statement, factor statement, which is, now I've lost my own list, which is CL.
Hang on just a second. So we're looking at the graph on 10, and we're looking at the big high point, or we're looking at the little peak for February of 2023, right? Ms. Stevens?
Yes, we're looking at the little peak.
Okay.
The little
And your
peak is in the
question,
blue. The
right?
big peak is in the orange, right?
And your question was, does what was the billing error responsible for that peak?
No, my question is, does Ms. Reza's graph reflect the billing error as opposed to the calculated value? And if we, I was
Okay,
asking
one question at a time. Okay, and your answer, Ms. Reza, was something about I have to look at the details,
right.
right?
Yes, ma'am.
Okay, are the details on the next page?
They should be on exhibit JIR2. At least for the blue line, right? I have the details in my testimony for the actual current month 12-month average FPPCAC that we're using on the blue line. So if I may.
Yes, where is that
real quick.
located?
Gonna be on exhibit JIR2 of my direct testimony. And oh, I apologize. I am so sorry. No, that one is not on there because it is 2023. That's not in that one.
Madam Hearing Examiner, may I continue?
Well, so can you tell us where the data is for your peak there in your graph?
So are we looking at the low peak, or are we looking at the blue line or the orange line?
We're looking at the current line over, mine's not printed in color, so
Okay.
I can't give you colors, but there is a peak that Ms. Stevens referenced over February of 2023. Where's the data that you used for that peak?
So we're looking on your black and white, because I have a similar copy, below the zero. That would be in my New Mexico 550 report for February, which I have included in one of our other exhibits that still has not been brought into evidence.
Okay, tell me where it is.
It is on exhibit 11, EPE exhibit 11. Attachment 1.
Madam Hearing Examiner?
Okay.
CLC
there you go.
Exhibit 25 is a cleaner version that's just as filed with the commission without the marginal stuff. And that was what I was trying to bring her to.
Okay.
It's up to you.
So you
whichever
want
way.
me to, well, if you got a better, it's your questions. I was just trying to get her there. Okay,
Well,
so it's CLC who?
CLC 25. And Ms. Reza, do you agree that CLC 25 is what you were trying to show in Exhibit 11 without, in the as filed format with the commission, without the red line and the notes to the right of the red line?
Yes.
Okay. So this is, and until you, and well, that is filed with the commission, correct? So that's a public record?
Yes, that is correct.
And your Exhibit 11 is not, because it's a discovery response, right?
Correct.
Okay. So let's looking at exhibit, CLC Exhibit 25. Would you agree that the little peak on February 2023 is, for those who don't have the advantage of color, reflects the fact that EPE admitted in that filing that it billed instead of credited 3.2 cents per kilowatt hour in the month of February 2023.
Okay, so your question is, what did we record for the factor for February 2023, what we billed for 2023?
Well, my question is whether your graph here, which is supposed to reflect use of the 12-month rolling average methodology, whether it in fact reflects EPE's use and errors in using that methodology.
Okay, so this, what we're seeing here on page 1 of 2 that you're showing, on line 3, that is the billing months factor that we calculated, which is a credit, which is what we're seeing on the graph on my testimony. And
I'm sorry? Where are we seeing a credit, a negative number on the graph in your testimony?
on line 3 with the blue line,
Yeah,
right, for February 2023,
yes. I don't,
where you see the drop.
I see the drop somewhere. Oh, oh, wait a second. So you're talking about the actual, yeah. Oh, so let's go. Let's try this again. Does this graph, let's not even talk about the specific numbers, but does this graph represent the factors billed in a given month or the factors calculated in a given month to be billed for the 2 months hence?
This should be the factor that we calculate. Let me, excuse me, give me a quick second. All right, I'm sorry, I was looking at the wrong line. Yes, so this is the factors that were billed.
That were billed.
Yes. So
That was where I was trying to get at.
Okay,
So
my apologies.
So your graph here, and the blue one is supposed to be the blue one, which is the one that poor hearing examiner can't see. That's the one that is supposed to be what the current factor produces, but it is in reality what EPE billed correctly or otherwise. Is that right?
Okay, so for February 2023,
Yeah.
what we billed the customers, yes, is the 0.031946 amount, which is on page 2 of 2.
Right.
And so, yes, that was the amount that should have been a credit to the customers, but because of the billing input error that Mr. Schichtel mentioned earlier today, it ended up being a charge to the customers.
And am I correct in concluding that it's in your rebuttal testimony, but that's because of that billing error and the adjustment that EPE made thereafter, that pretty much from that point forward, your graph does not reflect the actual results of the methodology absent that error?
I'm sorry, I'm not following the question.
So because this shows the charge instead of, you have not done a hypothetical calculation here of what the March 23, April, May, June, July, all the way to August of 23 would have been had EPE complied with its own methodology and billed in accordance with its own methodology. Is that right?
So if I'm understanding the question, yes, the error, the rate that we're showing for February 2023 is based on the billing input error. So that is showing what was actually billed to customers.
Okay.
But the error was corrected by April 2023. So through the mechanism itself, the error self-corrects. So after April 2023, the effects of the error are gone.
And that's the company's position, correct? I'm just trying to figure out what you actually graphed here, whether you're graphing what you billed or what a proper calculation would have been.
I am graphing what was billed.
Okay, so the fact that this graph starts to diverge in January 2023, but that's where the, the sort of rubber meets the road, and the mistake means that the interesting part of the graph is inaccurate. Is that right?
I'm going to object to that testimony. The witness just explained that by April 2023, the error was corrected. And so anything after that wouldn't be affected by the error. And so the question is inaccurate.
Well,
Ms. Stevens?
I first think the witness should explain it herself. And if she needs to, we'll go point by point and ask her whether those numbers continue to be completely unaffected by the billing error, because this is the point that Mr. She still deferred to her, and she's supposed to be the one who knows how to do it. And it's turned out to be a struggle to get her even to say that what the graph shows. But
Well, maybe we should go. I'm going to sustain the objection as far as I think it's going to be more beneficial for the record. The witness may not know what the interesting part is to you.
Okay.
So I don't think that really was an appropriate part to the question. But let's go month by month so that we have a accurate portrayal in the record. Ms. Riza.
And Madam Hearing Examiner, before you proceed, I would say that the city has some of those months as potential exhibits, but not all of them, the 2023 dates, just for point of reference. Obviously, they're available from the commission's website.
They are, and I think at this point, subject to the witness's understanding, I think we're just talking about March and April. So go ahead with your question, Ms. Stevens.
Okay, so you've just confirmed that the February point, the small sharp peak reflects the billing error. And my question to you, first of all, is if that error had never happened, and if you had correctly flipped that to the other side of the zero and provided a
wait, Ms. Stevens, wait. That's not what we were going to do here.
Oh, that's not
what we were going to do. We're not asking hypothetical questions about a graph she didn't do. Okay.
Okay.
I thought we were asking
about
questions.
The graph she did do.
Yes, ma'am.
Okay. So Ms. Reza, your testimony is that that each of the data points from including February 2023, each of the 2023 data points reflects what we would find in the monthly FPPCAC factor filing. Is that right?
Yes, that would be the amount that was billed and is also recorded in the New Mexico 550 reports based on the billing for that month.
And that's what you actually use, Ms. Reza, to make this graph?
Yes, ma'am. For the current actual 12-month factor line only.
Okay. Ms. Stevens?
Well, and do we need to confirm that against some of the actuals, or are you certain of that, Ms. Souza?
No, I am certain of that.
Okay. What was the April billing factor? The April billing factor, that would be so that would be what I've got asked you to open, which is CLC 25. You were looking at that? If you're looking at that, I've got too many documents open here.
Yes, so right now on CLC 25, The bill factor in February on line 3 is what we would have billed in April
Yeah.
or close, right? Because of the different voltages that they bill the customers. So would have been a credit, and that's what we're seeing in April 2023.
And I mean, I guess my question, the level of that credit. Ms. Reza?
Sorry, what was the question on the level?
No, so you're saying that that graph reflects what you looking at page 1 of 2 of the the April billing month, February costs. You're saying that the graph represents the calculation of a 0.019,812
It would be
credit. Is that right?
yeah, it would be close to that number because this is the factor that we calculated. We would need to look at the actual 550 for the current month of April 2023 and then look at the build line, but it would be close.
And do the numbers vary from month to month? Or you calculate in advance, then do you then calculate a different number based on the adjustments that you make for the voltage adjustments? Or
so you're asking
let me put that another way, Ms. Reza, since we've got or should have CLC 25 open. Yeah, too many documents open. Okay.
I
So-
have 25 on the screen.
Oh, I'm sorry. I've got too many screens open, and I can't see anything that tiny. So if we go, I'm going to go to my. Pardon me. My eyesight isn't good enough, Madam Hearing Examiner. I'm going to go to my big 25, and say. And for example, are you saying that when you calculate the billed revenue, I'm on work paper A? And at line 37, the billed revenues for the month in question, is that number there, that 0.31946, is that a number that the company backs into by calculating its revenues and dividing them by its kilowatt hours?
See, I think we need a different exhibit. This is February. I thought you were talking about April.
Well, this is February. This is the February costs are reflected in the April billing factor. So, but the February in turn represents what was calculated based on December costs to be billed. There's, I guess, I don't want to be testifying here, but there's still a 2-month delay element built into this process, I guess.
Right, and I thought she'd already testified about February and March, and you were asking her about April.
No, I think I was asking her about when she says that it balances out in
Okay.
April. Well,
Your question.
I'll follow on your question. Ms. Reza, when you talk about the billing error being reversed or washing out by April, are you talking about the April billing or the April calculations for June billings?
I'm talking about the April 2023 New Mexico 550 and the error clearing out of the balancing account.
So again,
That's not reflected on, hang on. That's not reflected on this exhibit then, is it?
No, ma'am, it is not.
Didn't think so. Do you have April, Ms. Stevens?
I just, before we go to April, I want to make clear that you're saying, Ms. Reza, that the April point reflects reflects April costs that are billed in May. I'm wondering about whether we're talking of two different things in the lag in your graph. I didn't think so before, but now Madam Hearing Examiner has me wondering.
No. So I'm telling, what is showing in the February 2023 number that we were just discussing is coming off of the February report, but the amount that was billed on page, you scroll down one more, right there. Oops, I'm sorry, a little bit up. Right there, under section 2, I believe. I'm sorry, it's a little small. I'm not sure if you can enlarge the picture that's being shared. Yes, thank you. If you look there at line 2B, oh, you were there.
Well, this says line 2,
I'm sorry, so if you scroll down section,
2A.
oh, I'm sorry, I was over here on section 3.
All right.
2, and then B, where we're showing a little bit further down, we've got the 4,161,778. You see that towards the bottom?
Right.
Okay, that's
And-
the amount that was billed to the customers and the KWHs that were charged, and we've got the rate there. The 0.031946 is what is shown in the graph for February 2023.
And then 0.031946, do you back into that number by taking the revenues, which are a hard number, and the kilowatt hours, which are a hard number, and come up with a factor that reflects the voltage adjustments and things like that?
For this line, yes, but the factor was calculated in December 2022. It's the FPPCAC factor from 2022. The only issue, of course, is that instead of a minus, it was entered as a positive. And so it'll be
Yeah,
close.
well, this number here, the that you're on the screen that's presently up, the 0.198, the 0.019812 is not the number that was calculated to be billed in February, right? This is the one to be billed in April.
Yes, that is correct. This is the amount to be billed in April.
So rather than beat this dead horse, let's go look at your graph, please, again on page 10.
Mhm.
And so we have this peak here in February that was the one that should have been a negative number. And then is it your position that the March number was unaffected by the billing error because you didn't know about it at the time you calculated the March billing charge?
No, I'm saying that the amount in March. Okay, so let me backtrack and make sure I can understand your question. So you're asking me if there's, can you rephrase your question?
Yeah, so we know that on this graph, we know that February is not what EPE calculated, it's what EPE billed.
Correct.
Then we go to March, that would be what EPE calculated in January, correct?
That is correct.
2-month lag. So at that point, you did not know anything about the billing error, so that is an actual calculated number that was not affected by the billing error. Is that right?
That is correct.
Okay.
But
Now
February,
we get to April, and that was and now we get to April, which is actually the February CLC 25, reflect the attempt to self-correct, as you call it, right?
yes, this is the factor that has been calculated that will correct the error through the mechanism.
And your testimony is that it corrected it all at once?
It corrected it through the process in April.
And thereafter, you believe that there was no effect whatsoever?
The balancing account amount, the over recovery from February cleared itself in April.
Let's look at, let me see if I can find whether I've got it in the my exhibits.
31.
31. Yeah, let's look at the, thank you. No, 31 is April 2024. It's 27.
Uh,
Okay. Would you open exhibit 27, Ms. Joseph?
Yes, ma'am, I'm doing that.
And can you explain how this completely, this reflects that so let's start with basic premise here. This is the calculation that you did based on April costs and billings to be reflected in June bills. Is that right?
Yes, that is correct.
But your position is that by now, by this point, the billing error had completely washed out. Is that right?
Yes, ma'am. And if I may, we do have an exhibit where I put together some schedules that will help clarify that.
You can have your own attorney put your new try to put your new exhibits into evidence.
Okay.
Is that okay?
All right, perfect.
Because I'm using up all my time here anyway. Would you look at Mr. Provencio's direct testimony, please? CLC Exhibit 1.
Okay.
And I'll take you to, I believe it's page 23 or is it 32? I'm turning dyslexic in my old age. Yeah, it's page 23 of his testimony, direct testimony. And I
Yes.
believe in your rebuttal testimony, you agreed that his figures here were correct. His recalculation of the cumulative overcollection
I agreed with his calculation through April.
through April, and that would be the April line, do you mean?
Yes, through month
Okay.
April 2023.
And you also agree that the second to the right column there, EPE reported cumulative, that is what EPE reported on its monthly statements?
Yes, I believe so.
So can you explain to me how, if you agree with Mr. Provencio's numbers, at least through April, and you are presenting the company, or he's presenting the company's numbers, how can it be that he calculated that the cumulative over recovery would have been 342,367, and you are still at you're still reporting an actual 8.66 million over collection. You agree with those two numbers, right? That those numbers are still right or correct?
You're talking about the May 2023 under the EP?
No, I'm still in April.
Oh, you're still in April?
Let's stop at April because you're in agreement with him about April. I want to know how you can, why EP is taking the position that the billing error or anything else reversed itself in April, and by April, if by the company's account, your total overage is still 8.7 million, whereas by Mr. Provencio's accounting, it would be in the range of, less than $500,000.
Right, so there's two things. So right now, what we're seeing through the April, the 8.6, the mechanism itself has a process in the calculation where the over or under recovery from 2 months prior is brought over to the following month. So the over recovery from February, and we're looking at just the month, not the cumulative that we're showing here, would be brought into the April calculation, and we would net that against the current month expenses. So basically washing out the activity from that period. And on this schedule that Mr. Provencio has put together, on the right side of his column, he's continuing to deduct the 8 million, the error portion from his column. And if we had properly included the credit, there would have been a different factor that you would have had to calculate, and you can't just remove 8 million for the following months.
Why not?
Factor would have been different.
And tell me why not? It was a mistake. This was a mistake that didn't have anything to do
Let her
with,
answer the question before you ask her another question, Ms. Stevens.
why not? That's the question.
As I was saying, through the methodology of the fuel mechanism, there is a reversal of the prior over under recovery. So in this case, the February current month over under recovery, in this case was an over recovery, would have been offset in April. So it basically removes that effect of the February error.
Ms. Risa, it's not going to show up until May?
It clears off in April. The cumulative balance that we're showing is always the current month and the prior month. So when you get to April, the activity or the balance in the cumulative account is composed of the current month over under recovery for March and April. So the February activity is no longer in the balance.
But the balance is still way up high, isn't it? Can you explain why that's the case?
That I would need to look at each of the specific 550 reports. There's various items that flow into that calculation. So it could be that we had bigger margins in that case that led to the over recovery on offsetting the expenses. The calculation itself is composed of looking at the expenses for the month and comparing to the amount that was billed to the customer, and that gets us to our new over under recovery for that month.
So we're looking at, in this instance, we're looking for differences that caused, under Mr. Provencio's calculation, that it would have, for February, it would have dropped from 15 million to 4.9 million, but instead it only dropped from 15 million to 3.2 million. Is that right? Can you show me where in the reports that size of a difference is justified or explained?
Okay, so I don't know that I have those reports already in an exhibit here.
Are those, well, I'll ask you, are you looking for the filed fuel close reports or something else in your possession?
Yes, so the filed fuel clause reports, because if we can pull March and April, I can show you that the current month over under recovery for each of those months will make up our balance that we've got of the 8 million.
So February's CLC Exhibit 25, March is CLC Exhibit 26, April is CLC Exhibit 27. If that helps you, maybe you can tell me which one you'd like to look at, or do we need to look at them all?
So if I'm looking at CLC 26, which is the March 2023.
Okay.
That one. is showing a, if you get to page 2 of 2, under section 3, and you've got the cumulative over under collection. Line C, the current month over under recovery is a 3,983,030. That's the current month over recovery.
So, and the current ones, so again, in March, the company over recovered yet again by almost 4 million. So,
Right.
right. Okay.
And if you.
And why, while we're still here, why does this process, which supposedly clears out the over recoveries by 2 months hence, why are we still up around 9 million, up 9.7 million?
Because that amount there is the cumulative amount, right? So if you look up on page 1 of 2, that gives us our gas costs, right? We see our gas costs on section 1. We see our net purchase power expense on section 2. And section 3, the 7.518 on 3A, that is the reversal of 2 months prior. So that's the over recovery from January. And when you net all those 3 numbers, we're showing that for that period, we've got a fuel expense of a credit of 7.7. And when you compare the revenue, which happened to be a credit, and you reduce the expenses, we end up with the current month recovery that's showing up of 3.983030 on the cumulative over under collection. And so that little section there on the cumulative over under collection is just rolling the balance. It's taking on line A, the cumulative over correction from prior month, which would have been from February, right? Because we're looking at March, if I'm not mistaken. That's that 13,252,000. Right. Yeah.
Excuse me, where is the 13 million? I see
Go down right there, section 3. And then right there in that section where it says cumulative over under collection, that A.
Okay.
There's the 13 million. Then we back out the second month recovery. So there's the January over collection that's being reduced. And then we're adding the current month.
Okay, well, the city moves to admit or take administrative notice and put into the record CLC exhibits 25, 26, and 27, which are explanatory of what Ms. Rez has just been talking about.
Normally on a commission filing, I would not include them, but I think they're helpful for this case.
Yeah.
So
They're really
subject
hard
not,
to find.
would you mind if I ruled on your
Yes.
exhibits, or you want
Yes.
to keep talking?
Pardon me.
So I was indicating normally I would take administrative notice, but I do believe that these exhibits are helpful. And if there's no objection, I will admit CLC exhibit 25, which is the February 2023 FPPCAC filing, CLC exhibit 26, which is the March FPPCAC, March 2023, FPPC, CAC 550 filing, and CLC Exhibit 27, which is the April
Thank you.
2023 FPPCAC exhibit. Go ahead, Ms. Stevens.
Thank you. And pushing my luck a little bit farther here, would it be appropriate to move to admit CLC Exhibit 23? No, pardon me. 24, which is the factor filing for December 2022, which generated the number that should have been billed in February 2023, kind of closed the loop.
I don't believe that the witness has testified as to this exhibit.
Ask her. Is that the source of the number that was correctly calculated but erroneously? The CLC 24, Ms. Reza, the source of the calculation that was calculated for February but erroneously billed as a positive rather than a negative number?
Yes, December 2022 has the FPPCAC factor that should have been billed in February 2023, if not for that billing input error.
So for the same reasons that the Exhibit 25 through 27 were admitted, the city moves with the understanding that it ordinarily would be administrative notice, moves to admit CLC Exhibit number 24.
Any objection to admitting the December 2022 F550 EPE filing identified as CLC Exhibit 24? Hearing no objection, CLC Exhibit 24 is admitted. Ms. Stevens?
Thank you. Thank you. Ms. Reza, so in your rebuttal testimony, you take issue with Mr. Stridell's testimony about the potential use of the balancing account factor. Given the numbers that we were just looking at, the fact that that even with an adjustment, the cumulative balances stayed high, did the company at any point consider making a voluntary adjustment to bring down that cumulative over recovery?
So I just want to confirm the question is, did we consider making an adjustment, meaning something other than running it through the FPPCAC factor?
Right. Under the discretionary powers to use a balancing account to do justice, I guess, or to do something that's more reasonable. Did you ever consider that option?
Yes, I believe Mr. Schistrel has mentioned that earlier, that there were other options that were considered.
And is that, I know that by 2023, you were manager of regulatory accounting. Was in this particular instance, was that, or in that particular period, in the spring of 2023, when the balancing account numbers remained high, did the company ever consider using that power to mitigate the impact on customers?
So you're saying after April 2023? Is that
before or after? It peaked, the number peaked at 15 million in January, is that right?
That sounds about correct, subject to check. Yes, so the factor, as I mentioned earlier, is self-correcting factor that corrects every 2 months. So we consider that to be a pretty quick turnaround on adjusting the over-under recoveries.
But the cumulative over recovery remained very high for a number of months. If we go back to Mr. Provencio's exhibit, is that right?
Yes, I believe that was correct.
You got 2 minutes.
And you didn't try to change it, did you? And with my last 2 minutes, I'm going to ask you, Ms. Reza, to change course here. Go to Exhibit JIR 1R and show me where on Mr. Hernandez's exhibit that you've incorporated into your testimony. Show me how you would how you would have gotten the average, how it would have been obvious to the commission in case number 20-00104 would have been obvious how that you were intending to calculate the rolling average using a price rather than a cost factor.
Okay, if you look at, I'm sorry, I'm struggling with the PDF. On page 9 of 14.
So you're going to start at the beginning of the implementation? Oh, okay.
Oh, I'm just going to show you where the calculation was on page 9 of 14. There's a line that was added right above section 12.
Yes.
Right, and it says added to calculate 12-month average factor. So in the calculation of that factor.
And I see that row, but I don't see, it's not obvious to me how those, well, two things aren't obvious to me. Maybe you can help me with each of them separately. It's not, or maybe they are really the same thing. It's not obvious to me where each of those numbers came from in terms of average cost or average price. And it's not obvious to me if you run the row going, horizontally, whether if you took each of those numbers.
You're asking too many questions.
Okay.
It's totally confusing.
First of all, how do you get each of those? How do you get each of those numbers in that added to calculate 12 months average factor from the numbers already on the page?
Okay, so I'm just looking at the first column there on page 9 of 14, which happens to be January 2014.
Right.
And that is going to be calculated by looking at the total fuel and purchase power. Also, let me see, I'm sorry, I'm having trouble with the file here. On section 9, I'm on the wrong line. On section 7, applicable fuel and purchase power.
Okay.
There's a total there of 5.530272. See that? Do you see that line? Line 7C?
I'm sorry,
Page 9 of 14.
Maybe I'm in the wrong. No, I'm sorry, I've lost my page here. Forgive me. Okay. So got you now. So you're saying that
go ahead, Ms. Rosa.
Okay, so on 7C, under the column of January 2014, there's a total of applicable fuel and purchase power expense of 5,530,272.
Yeah.
So it'd be that amount divided by line 8A, which is the KWHs that were billed that month. And that's how you get that first rate for January 2014 of a negative 0.0395. I can't see the rest of it. I'm sorry, it's a little too tiny even for me.
Yeah. I actually I went to the original Hernandez exhibit because these numbers were so blurry. But you did testify that you've examined this, right?
Yes.
So, and is this the version you used, the one that you attached to your testimony, or did you have a spreadsheet?
No, this was, well, I don't recall. I'm sorry, I don't recall. I believe I did look at the spreadsheet.
You did have a real spreadsheet with legible numbers?
Okay, you're out of questions, Miss
Okay.
Stevens. Okay,
Can I
so
ask one
I just want to
question?
know.
Can I
No,
just ask one question?
you want to
Madam Hearing
let me
Examiner?
finish, Miss Stevens? Now, the question was, Miss Reza, how you utilize this exhibit to calculate. Was there any other part for the explanation of how you utilize this page 9 of 14 of JIR1R to make the calculation?
Yes, so if for looking at each of these line items on here, where you're looking at line 11B, where he's got the rolling, or we've got the rolling 12-month average calculation. That point, it's a negative 0.043242 under September 2014. We would have used the 12-month average factor. That's right above
And
line
let's,
12.
do you mean September 14th, or is this year 2014?
It's for September 2014. I'm just using that one as an example, but for each of the items that are on line 11B, we would have taken the amount that we calculated as the 12-month average factor, summed those up for the 12 months, and then come up with the factor to use on 11B.
May I ask one question? I know I'm past my time.
Okay, let's let her finish. Is there any other information on this sheet that you utilize to make those calculations?
No, that is all.
Okay. Last one, Miss Stevens.
Okay, so Ms. Reza, are you, when you say that row that you've added that says rolling 12-month average calculation, if I were to take going, and seems to be where it starts, so maybe if we went to a different page, if I find that same group of numbers, again, it's on 11. I'm down now on page. Oh, just to make it clear, I'm on. Yeah, where are the page numbers? I'm sorry. I'm on the 2016 data.
Okay.
If you will. So
page 11 of 14.
For some reason, I'm not seeing the header, Madam Hearing Examiner. But so to get that, so that rolling average, rolling 12-month average calculation, does that already contain the rolled in information, or can you take 12 consecutive months going horizontally, total those up, and get your 12-month rolling average?
So for which line are you trying
I'm
to?
I'm on 11B.
11B. Okay.
And I'm wondering whether one could take to get the rolling average for either the last month on that year, or the first, or maybe it's the January of the following year. Would you take each of those numbers on line 11B and sum them up and average them? Your testimony is about a summation, and sum those up to get an average to be billed in the last or the next following month? Or is there another, well, let me just answer that question. Would that work?
So to calculate line 11B, if I'm understanding your question correctly, line 11B would have been calculated by using that line that's right below that said added to calculate 12-month average factor. And we would have to pick up or sum up everything from February of 2015 through January of 2016 and divide that by 12. And then you're adding it to line 11A, which is the current month component of the factor.
Okay.
To
So
get you to
so your
11C.
answer is yes, you could by summing the added to calculate 12-month average factor, those numbers would sum up to get your actual building factor? Or
You would have
partly?
to, I'm
Yes?
sorry? I'm sorry.
If you summed up, this added to calculate 12-month average factor, is there a row is there a set of numbers on this document from which one could total up numbers, 12 consecutive numbers, divide them by 12 and get the rolling 12-month average component of an actual bill?
So to get to the factor that we've got on line 11B, looking at your first column there of January 2016, the amount is a negative 0.034245. You could add the line below that says added to calculate 12-month average factor. If you add that amount from February 2015 through January 2016 and divide that by 12, you should end up with the amount on 11B.
But what she's asking you is there a row on that exhibit? If you took the numbers just from that row and divided by 12, that you could say, oh, well, that's the average of the 12-month rolling average.
I guess I'm missing the question. I apologize. I'm not following the question.
Okay. She's asking you if you looked at 11B, which is the rolling 12-month average calculation, right?
Yes.
And you added all 12 months and then you divided by 12, could you say that is the average of the 12-month rolling average? Or would you have to include some other lines in order to come up with something you could characterize as the average of the 12-month rolling average?
Okay, so let me see if I think I'm following the question. Let me see if I can clarify. So as I mentioned earlier, the line added to calculate 12-month average factor that we're seeing there in January 2016 of the credit of 0.029987, I believe is the number. That is calculated by taking the applicable fuel and purchase power expense for that month on 7C divided by the KWHs. And so we've got that number there for every single month, right? So if you take that number from February 2015 through January 2016 and divide it by 12, that'll get you the amount on 11B. Am I answering your question?
Ms. Stevens, do you understand the answer?
I think so. If you could just tell me which 11B, would it be the December here or the January in the next?
No, for the January 2016. So if we're looking at January 2016, it would be that current month calculation plus 11 months, right, to get us to 12 months. So it would be February 2015 through January 2016.
So you're saying you go backward, not. I was thinking we were looking on this page that you would go to January 2017 and sum up and divide by 12. Would that also work?
To get the number for January 2016, I wouldn't know the future numbers, right? When we're working on these, I guess I'm not following the question.
No, I think what I'm saying is.
I think the witness testified how she got the number, Ms. Stevens, and your
All right.
time is up. And I
Okay.
think now might be the appropriate time. I've got 10 after for us to take a 10-minute break, and we'll come back. And I believe Ms. Souls has reserved 20 minutes and staff has reserved 10 minutes for Ms. Reza. So
And I'd
we
like to-
are recessed until 20 after 3.
Madam Hearing Examiner, Ms. Reza, I'd like to thank you. It's a slog here. Thank you both.
We're recessed. Remember, the YouTube is on.
Oh.
Mr. Lee, that's a serious water bottle.
And I drink a lot of it. And I fill it
My-
up at every break.
I feel mine is inadequate.
I can't comment.
I think we're, that's good. Drinking water is good. I don't drink enough myself. Well, I think we're ready to come back from our recess. And Ms. Solz, you reserved 20 minutes for Ms. Reza?
Yes,
Go
ma'am.
ahead.
Thank you. Good afternoon, Ms. Reza. I'm Mary Lee Souls. I'm a pro se party in this case. I'm going to ask you to go to your direct testimony, exhibit JIR-2, what's represented as page 342 of 390.
Okay, give me a second, please. Okay, yes, ma'am.
Would you please describe what we're looking at here?
This is work paper A to the monthly 550 for March 2022.
And how is work paper A used?
Work paper A is the supporting documentation for the New Mexico 550. And it includes total company costs and provides the allocated cost for New Mexico jurisdiction.
Thank you. And before we go farther, I note that it says work paper A, page 1 of 4. I'm assuming that's related to the calculations for the month of March 2022. Is that right?
This is, yes, and one other thing I wanted to add, so yes, it is the calculation of March 2022, and at the end, we get to the factor that we will be billing customers 2 months later.
Thank you. But I also noted that there's a page 2 of 4, but I want to ask you, where is 3 of 4 and 4 of 4?
On our annual report, it's a little funny, so we've got the work paper A, page 1 of 2 and 1 of 4 and 2 of 4 together, and then you have to kind of scroll down to find the others. Let me see real quick. And I apologize, I'm looking at some hard copies here. Give me a sec. This is March 2022. So page 378 of 390 of the exhibit has page 4 of 4, and then let me find page 3 of 4. So page 366 of 390 is work paper page 3 of 4.
All right. Thank you. That's very helpful.
Yes, you're welcome.
I wasn't sure if I was finding the right ones. Let's stay on page 342 of 390.
Okay.
And I'd ask you to look at line 5. Can you tell me, please, what is this representing?
Okay, line 5. Okay, so line 5. Line 5 on page 342, correct?
Yes, ma'am.
Yes, that is the gas cost for the Rio Grande plant.
And is that gas cost based on what was consumed at Rio Grande in the month of March 2022?
That is the actual cost recorded for the month of March 2022.
Let me ask that question differently. Is this an invoice value that was invoiced in March, or was it what is represented as consumed in March?
It would be invoiced amounts with any estimates that might have been required.
And then do I understand that you would get this number directly from the invoice payments? It's part of the accounting system. Is that correct?
It would be coming from our general ledger. So would include invoices and any other costs as necessary.
Okay. How do you determine which values of gas purchases apply to Rio Grande versus Newman versus Copper or Montana?
Everything in our general ledger is in detail by, well, I'm not going to say everything. For the specific gas plants, we do have specific accounts detail by plant in our general ledger so that we can generate the data that's required here.
Would that mean that when El Paso Electric makes a gas purchase from one of its suppliers, that specifies at that point in time that gas is intended for Rio Grande?
I can tell you that what I'm utilizing is what got recorded into the general ledger for that plant. The actual invoices are coded by another department.
Very well. Could we go to line 26, please?
Yes.
It says PV3 excess sales credit to customers. What is this?
Yes. So with the New Mexico with the final order in our New Mexico 2020 rate case, as mentioned earlier with Mr. Jim Shishel, the PV3 proxy price was no longer adopted. And so we have entered into an agreement to sell the portion of the non-Texas PV3 into the open market. And we do a calculation that compares the PV3, that sale that we entered into against the actual generation for PV3. And the difference is applied at the rate of that contract, and that calculation gives us margins that were made off of that sale, and we allocate that corresponding portion to New Mexico.
Then what is the value here? $111,760 for total system.
That is the total amount, as I mentioned, about the difference in the kWh's from the sale compared to the what was generated at PV3 times the rate in the contract that we had in that sale, and that's for total company number. And so to that number, we'll multiply that by the allocator or percentage for New Mexico, that's on line 2, to come up with the portion for New Mexico of the 22,878.
So do I understand you correctly that El Paso Electric has sold that non-Texas portion of PV3 capacity and the energy it produces? Is that correct?
We have entered into a contract for that portion of it. And that's my limited understanding. I'm not the one that actually makes those transactions.
Is this indicating that that contract is being serviced with more energy than that non-Texas portion of PV3?
It's saying that the sale that we made was larger than what PV3 generated.
All right. And is El Paso Electric not treating this as an off-system sale, but as something unique?
So this one is, I guess, let me come back to that. I believe that for the exact terminology, I'm not exactly sure if it's still considered the same as an off-system sale, since I'm not that familiar with all that terminology. But we are identifying it separately because we do a separate calculation in coming up with the margin for this item.
What is the calculation that you do to come up with the margin?
This calculation, what we do is we take the PV3 generation, multiply it times demand allocator, and come up with the amount that's non-Texas, compare it to the kWhs sold in that specific contract that we entered. Taking the difference of those two, we take those kWhs times the contract price for that sale.
I thought you said margin, which means there would need to be a cost related somewhere, or did I misunderstand?
Well, this one is basically just the excess sales related to that transaction. And so we do that separate calculation.
Are you saying then that this is a revenue amount?
Yes, anything that's here on the interchange out as minus is a revenue or a credit back to New Mexico.
We'll come back to that. How long, first, before we go there. No. For how long has this line 26 been included in the work paper A?
That one has been here since July, August 2021, subject to check. It was effective with the final order in the 2020 rate case. And actually, now that I remember, let me think about that. I believe we did a prior period adjustment as we were determining the methodology in November or December of 2021.
Did you complete your response?
Yes, ma'am.
Very, very well. Is this credit still showing up every month in the 550 filings?
Yes, ma'am.
Thank you. So regarding the entire page here, where's the revenue from off-system sales credited?
The revenue from off-system sales is composed of two lines here on interchange out. And it's the firm and the 100% margin sharing. And that is the total margin that is allowed to be shared for those sales.
What lines?
Line 20 and 24.
And a minute ago, you indicated that line 26 is actually a revenue number, correct?
Yes.
And if I understand you, there is not a revenue number standalone for the rest of the off-system sales. Is that also correct?
It'd be a combination of line 20 and 24.
And line 20 represents what?
Just basically the total sales less the margin sharing. Or the cost, I believe that Mr. Shishel mentioned earlier as well.
Line 20?
Yes.
I thought I heard you say something related to cost plus margin sharing equaled revenue.
Yes, the line 20 has the cost portion and 24 has the margin. So together that makes the total sale.
Thank you. And where does the value for cost come from?
That would be something that be better handled by Victor. I'm not involved in that calculation.
What is feeding your work paper then?
We've got summarized information that we get from another department that provides us the details.
And what is that information?
The same information that feeds into line 20 and 24.
Does it have a name?
What do you mean a name?
Well, if 20 and 24 together make up the revenue amounts, something is determining how to break those down into cost and margin. Would you agree?
Yes.
And so I'm asking you what that is, if for no other reason, so that I know what to ask Mr. Martinez.
It's total power sales is my understanding. And then they break out line 20 under firm right there, which is the cost related to that sale. And then line 24 is the margin.
And when you say they, is this what you're referring me to Mr. Martinez?
Yes, so my understanding is Mr. Martinez's group does the actual sales transactions, and they get detailed information that is forwarded to energy accounting, and they summarize the data that breaks it out into these categories based on the information they've entered.
On line 20, if this is cost information, is it fair to say that this cost line is reimbursing El Paso Electric customers for the fuel cost for the energy that was sold off system?
I'm sorry, I'm not sure about that. I just know that these are the total sales, and I'm required to report them on these two separate lines.
In this section, interchange out, these are represented as negative numbers. Could you explain that, please?
Yes, so these numbers here are showing as negative because they are sales, and they are credits that would be a credit to the fuel and purchase power costs.
You're at 2 minutes, Ms. Souls.
Yes, ma'am. Does all of the revenue from off-system sales get credited to customers?
All of the margins are credited at 100%.
Does all of the revenue?
So all of the power sales are included in line 20 and 24, except for the sale that we mentioned on PV3, which is on line 26 based on the calculation we discussed.
Then your answer to my question is yes?
Yes.
Thank you. If the costing models or whatever other calculation is feeding this were to assign higher costs to off-system sales, what would be the impact?
It would depend, I guess. I'm not the one that creates that calculation, so I think you would need to look at the total, right? Because the margins fluctuate as well. So I can't
Would you
answer that
agree with
question.
me that, would you agree that higher costs would result in lower margins, but that the same amount would be credited in this section interchange out?
If you're assuming that the total is the same, let's say here we have 5 million for a firm and 1 million for margins, a total of 6 million. And so you're starting with the 6 million and the firm amount is now 5.9. Then the margins would be lower and the amount would be the same, I would assume. But I'm not the expert on these calculations.
Last question, Ms. Souls.
I'm afraid my questions that I had left are more complicated than I can do in a single question.
Okay. Thank you. Mr. Black, I believe that staff reserved 10 minutes for Ms. Reza. Go ahead, sir.
Thank you. Can you take the screen share away, please?
Absolutely.
Thank you. Good afternoon, Ms. Reza. How are you?
I'm doing good, Mr. Black. How about yourself?
Okay, I'm doing fine, thanks. I represent the utility division staff of the PRC.
Yes, sir.
And may I refer you to your to EPE Exhibit 4? That would be your rebuttal testimony.
Yes, sir.
Could you go to page 11?
Yes, sir.
And then lines 12 through 19. At those lines, you reference a March 1st, 2023 email.
Yes, sir.
Who was that sent to?
I'm gonna look at my exhibit JIR 3R, and that email was sent to Mr. Bradford Borman.
And do you know who Mr. Bradford Borman is? Was at the time?
Based on discussions with my legal counsel, my understanding is he was counsel for staff.
Okay, thank you. Does the email say anything about staff counsel? What does it say? What did staff counsel do? What is that exhibit JIR3? I'm sorry, is it JIR3R?
JIR-3R, yes, sir.
Okay. Those are examples of staff doing what?
It's basically discussions or follow-up emails from our legal counsel with Brad, letting them know that, hey, we're gonna call you. We've got a billing error that was made based on the factor from December 2022 caused an error in February 2023. And then basically some discussion, when can I call? They said it, basically Mr. Bradford says, go ahead and call me and I'll get back to you. Then there's another follow-up email on March 10th where EPE counsel reaches out to Mr. Borman and lets him know that the report that we're working on is ready and seems to have attached it on here and saying, hey, please let us know if you have any questions. If not, we're going to go ahead and file it. So basically just confirming that they're aware of the situation.
By aware of the situation, is it your understanding that staff's legal representative, Brad Borman, was aware of the February 2023 billing input error?
Yes, sir. That's my understanding.
How do you know that?
Based off of the emails that are on here and discussion with our legal counsel and conversations they've had. That our legal
Okay.
counsel had with staff counsel.
All right. Did Mr. Borman or staff counsel raise any concerns about how the error was going to be corrected?
No, not that I'm aware of.
How do you know that?
We ourselves, we in my department were in contact with our legal counsel, and we were included on the emails. And we did not see any responses or concerns being brought up on email.
Okay. And finally, did Mr. Borman review the Form 550 for February 2023 that was attached to those emails? I mean, it was attached.
I am not aware whether he did or not because we didn't see a response via email.
Okay.
I'm not sure.
All right, then. I have no further questions.
Thank you.
Thank you, Ms. Black.
My pleasure. Thank you.
Good afternoon, Ms. Rosa.
Good afternoon.
I've got a few questions for you.
Okay.
And I believe, as Ms. Stevens indicated, welcome to Testimony Land.
Yes, thank you.
Are you having fun yet?
I'm trying.
Good. And I'm just trying to understand, and I'm actually here trying to look in the info share, our e-docket or filing system.
Mhm.
And I'm not looking in the right place because I'm only showing an annual filing. So let me just go ahead and ask you, are you the one that actually makes these monthly 550 filings?
So my team prepares them, and then we have another individual that reviews them, and then I do the last review.
But who actually sends them to the commission?
Usually the individual that prepares it, lately here it's been Mariah Novella.
And in looking, I'm just going to pull up one of these from the Dropbox.
Okay.
Let's get one that's been admitted. And I believe, there we go. All right, so Ms. Novella is the one that sends the monthly filing, and this is CLC I'm looking at. Let me share it. I'm looking at CLC 24, which is the December one.
Okay.
And looks like to me in the 2 column here, it has that it's going to records, so it actually gets filed, correct?
Yes.
And looks like we have lots of El Paso Electric people on here. Are you aware of anyone else that the monthly filings get emailed to other than records?
As far as I am aware, This is where, and you're talking to the commission or just anyone in general?
I'm talking about both.
Okay, yes, as far as I am aware, we do send out this email, and like you notice, there's a lot of EPE individuals here that get CC'd on there. And it's my understanding those are the only individuals that see it, unless with the exception, like when we had the February 2023 error that we were discussing right now, that we do reach out to the commission for that, or we reached out to the commission for that. And as far as I know, those are the only individuals that we email it to.
Okay. So do you usually file it on the same day every month?
We aim for the due date, right, which is normally 5 days before the end, 5 business days before the end of the month. So it's normally around the 19th, 20th of the month.
Okay. So now we're looking at CLC Exhibit 25, which was the February 2023 FPPCAC. And again, it looks like it's going to records, and then it's going to EPE people, correct?
Correct.
Okay. Do you know if Miss Novella or some other El Paso Electric employee or yourself, if anyone at EPE specifically sends the 550 reports to any member of staff?
As far as I am aware, for end of month, after we file, we do not send it separately to other individuals.
Okay. If a staff member, or for example, one of these nice people who have intervened here in your case, if they happen to be looking at the 550 that you filed, and they called up and they had a question about it, who would they talk to? Would they get to you, or would they get to Miss Novella, or would they get to somebody else?
I would think that they would get to Ms. Novella, since she is the one that signs the letter. And if there would have been a concern, then she would have notified me, and then depending on the issue, right, we would notify others in the company.
Okay, go ahead.
I was just going to mention with the February 2023 error, I know that we did get an email also from Mr. Alan Downs, which is my exhibit JIR-4R. So he specifically reached out to Mariah, asking her some questions about the value, because he did notice that we should have charged a credit or recorded a negative instead of a positive. And so she discussed that with him and let him know that, you know, what the situation was, and he seemed to be okay with that response.
And is Miss Novella, are you her supervisor?
I am.
Any idea how Mr. Downs?
I'm assuming he was looking on the website.
Okay.
I don't.
He likes to review 550s, you think?
Apparently. I'm not sure if he put something in his email. I don't recall the details of his email. But he was looking at the report because he specifically asked about the page, the line number.
Yeah, no, I see that in the exhibit. No, I'm familiar with Mr. Downs. He's very detail oriented. So I thought that there were some processes that, for example, the company notified, like, not just the legal division director, but notified, for example, the utility division director, or they notify, I think, I believe in the variance case, the 21-00064, I believe that Ms. Dashino, the head of the accounting department, was the witness in that case. And but you're not familiar with at least as far as FPPCACs go, that there is some other either pre or post filing communication with staff.
Correct. I am not aware. If we are informed of an error, then, my staff or whoever receives the notice will tell me, I go tell my director, and then we reach out to our legal counsel. Depending on the magnitude, right?
It's nice to have a team, isn't it?
It sure is.
Hearing examiners, we're lucky to have people like Mr. Lee and Ms. Kippenbrock, our assistant. That's kind of our team.
Yes, definitely comes in handy.
We have no lawyers to help us, or accountants, or engineers. I wish we did. They're actually, the commission has been hiring some technical advisors in the recent administration. Unfortunately, the state can't pay like the private sector. So I think you all scoop them up first.
Yeah, I hear that's always a problem, right?
It is.
For governments or government agencies.
Well, sometimes we can get them out of school, but then they get trained and they leave us. Our return on equity witness from a few years ago, one of the other electric companies scooped up.
Uh-oh.
So I noticed in your qualification that you're a certified public accountant, correct?
Yes, ma'am.
And it says you were employed by KPMG.
Yes, ma'am.
In the early 90s?
Yes, ma'am. So a long time ago.
What kind of company was that?
That's a public accounting firm, similar to PricewaterhouseCoopers. I don't know if you're familiar with that name, but it's external audit and public accounting of we do public accounting and work on audits for various companies, or did. I apologize.
But pretty much your career has been with El Paso Electric?
Yes, ma'am. Majority of it has the last 20 some years.
So just on the basis of what we've been talking about with the email of the 550 filings,
Yes.
on your direct testimony, El Paso Electric Exhibit 3 on page 5, question 11, the question posed is, does staff have the opportunity to review the 550 reports? And then you begin your answer in item 11 and you say, utility staff receives the 550 reports and has the opportunity to comment or object. That's correct? That's your testimony?
Yes, that is my testimony. And just to clarify, through receives, I guess I should have clarified, it's a public document, right? And I would think that they would be, have access to them as others do as well.
But you don't have any specific information of a process, since they're not receiving these through service by EPE, are you aware of any process or procedure that staff utilizes to find out about these filings and review them?
I am not. I just, as you saw in that email, we send it out to the commission based on the address that we have. I'm not aware that we send a separate copy to anyone.
Okay, I want to look at your testimony at page 7. The
Yes.
question posed, question 16, from an accounting perspective, is there value to a commission order granting reconciliation? And your answer beginning on line 18 says, from an accounting perspective, a commission order granting reconciliation of the fuel and purchase power cost is not necessary. That's your testimony, correct?
That is.
Well, what as not an accountant, but as a person in a regulatory role, do you think from a regulatory perspective that the commission might see some value in having reconciliation done?
Well, my understanding of reconciliation is basically the confirmation, right, that the revenues and fuel and purchase power costs have been appropriately matched, of course, with the difference going into the balancing account. And so I guess I don't really think it needs to be a requirement. It's I guess a nice to have from my perspective.
Okay. And then the next question, can EPE close the books from an accounting perspective, even if the commission does not address reconciliation? You answer line 4 on page 8, EPE can and does close the books monthly, even if the commission does not address reconciliation. So can you just define for the record what you mean by that EPE closes the books?
Mm-hmm. So basically each month, right, we need to ensure that we've got all of our revenues and costs recorded on our system. And if we go through this continuation filing and we do not get a reconciliation, that doesn't preclude us from continuing with our process, right? If there would have been, I guess the only thing that I can see that would come if there was something that was noted that was incorrect, or we had to redo something, we would have to create some sort of an adjustment on our general ledger. But if we go through the process and we're told that everything's reconciled, or there's no discussion of whether we've reached a period of reconciliation, we continue on with our process, assuming everything's okay, because we haven't heard to the contrary.
even though EPE may have closed the books on a particular month, on a particular issue,
Mhm.
do you think that precludes the commission opening up the books on a particular issue in some future proceeding?
No, I don't. If there is an issue, like, I mean, even now, right, we're doing reconciliation, and our period that we have on my exhibit JIR2 is 2017 to 2022. You could at this point find that, oh, you know what, there, you've got an error, we need to fix it. So we would have to report that in the current year. And depending how big the adjustment is, and discussions with our auditors, if it was large enough, we might have to go back and restate our financials.
Okay. I have one question with regard to your chart on page 10.
Yes.
And you're talking about on line 14, the variability in the monthly factors. And can you just define for the record what variability means to you?
So variability means to me just a lot of fluctuation where we don't have necessarily a straight line. And in this case, variability would be related to the fuel and purchase power costs, right? Fluctuating and being able to kind of limit the impact of that factor.
And I just wanted some clarification on an issue that I believe you've been asked about before. And if we look at page 5 of El Paso Electric Exhibit 4, one of the interveners witnesses was commenting about at line 12, EPE is using a 12-month price weighted rolling average rather than a 12-month cost weighted rolling average. And you disagreed with that testimony, correct?
Yes, I did. And I disagreed with it from the perspective of the fact that we're doing it in accordance with the final order. And we are starting with our actual fuel cost as the starting point to calculate our rate per kWh or our factor.
And from an accounting perspective, do you believe that the way you're calculating it not only is in accordance with the final order, but it's also in accordance with whatever accounting rules that are applicable to regulatory accounting principles?
Yes, I mean, there's nothing specific that tells us how to calculate this factor. And for regulatory purposes, we follow the directions that we get in approved final orders. So yes, I believe that we are doing it appropriately. In addition, if I may add also, there was an exhibit from staff as well They got similar, probably the actually same questions on that. I can mention what that exhibit is. Am I allowed to do that?
Sure.
First response. So it'd be staff exhibit 3. And they do agree with EPE following the order, the final order, and also add a little bit more information as to why they believe that the way we are calculating it at a cost per kWh is more appropriate.
Is the way that you're calculating it now for the rolling average, when you were calculating it before just based on the month, did you use price or did you use cost?
Similar to what we're doing today, we would use the actual cost divided by kWhs, and the difference was that it was only 1 month's worth of cost instead of the 12 month.
And if I understood the testimony correctly, every month you add a new month and drop off the oldest month. Is that correct?
That is correct.
But even though you're using this 12-month methodology, you're still on the 2-month time lag for, I don't want to use the R word, for actual implementation.
Yes, that's correct. So whatever factor we calculate today, let's say we're in the month of, I don't even know what month I'm in, June. We would be calculating the factor that would be used 2 months later in August.
Okay. Yeah, I didn't want to use the reconciliation word. That's why I said the month implementation word.
I'm okay if you're okay with it.
You just have to be careful in this business, the word, because sometimes the word means different things in different times. And just so the record's clear, page 22 of your rebuttal testimony, you're talking about temporary reallocation of capital B, capital V1 to the RPS rider have been removed from the FPPCAC filings effective February 2024. That's your testimony?
Yes. Which specific line are you on?
Yes, ma'am. You're answering the question on page that was posed at the bottom of page 21.
Okay, yes, I see.
That was your testimony?
Yes, that is my testimony.
And for the record, can you just identify what BV1 is?
Yes, BV1 is Buena Vista. It's one of our renewable energy facilities.
Thank you.
I'm sorry, a purchase power agreement related to renewable energy.
Okay. Very well. I think that's the questions that I had, Ms. Reza. Thank you.
Thank you.
Mr. Wexler, you have some redirect?
I do. I would say approximately 15 minutes.
Okay, go ahead, sir. And are you going to include the explanatory exhibits that Ms. Reza referred to earlier?
Yes, I am. In fact, that's where I'm going to start with EPE
Very
exhibit.
well. Excellent. Thank you.
So, Ms. Reza, you were asked a whole series of questions about what were CLC exhibits 25 through 24, and those were the Rule 550 reports from December 2022 through April of 2023. Do you recall those questions? Are
Sorry.
you?
Yes, I do. I apologize.
And I think that the issue that we were talking about was the billing, how the billing error from 2023 was flowed back to customers. Is that correct?
Yes, that is correct.
So you referred to in part of your answer to EPE Exhibit 11. And what I'm going to ask you to do is to call up EPE Exhibit 11 and directing us to whatever parts of that exhibit you think are most helpful for the hearing examiner and the commission to be paying attention to. Just walk us through that whole process through the recovery to the customers.
Okay, all right, I will do that. So if you open up EPE Exhibit 11, we've got 3 attachments. And I am going to I'll start with attachment 2. Attachment 1 is the February 2023 FPPCAC or New Mexico 550 report with just details as to what's included in each line. But if we move to attachment 2, on attachment 2, I have included a couple of notes and some screenshots from the December 2022, February 2023, and April 2023 New Mexico 550 report. And what I'm trying to illustrate with this is the way the over or under recovery flows into the following month through the process of the mechanism. So, yes.
No, please continue.
Okay, so as noted on the first note, I'm going to start with going to page 2 of 5. And on page 2 of 5 on line 41.
And just so we're clear, this page that you're showing here, we're looking at the December 2022 Rule 550 report. Is that right?
Yes, that is correct.
Okay, please go ahead.
So if you look at line 41, that shows that for December 2022, we had an over recovery of 7.5 million. And when you look at line 43, you can see that there's a 7.5 million a little bit to the left. And on the right, we've got the factor 0.059465. And that's calculated using line 41, the over recovery divided by the KWHs. And so that becomes our first component of our factor. And then line 44 has the 12-month average component. And then line 45 is the factor that we calculated to bill in February 2023. In this case, since we have an over recovery, this is the amount that should have been a credit to the customers in February. Okay, so as we know, we had a billing input error. So instead of charging the customer, giving the customers a credit, we ended up charging the customers. And so what I wanted to show is keeping in mind line 41 and 43, the amount of the 7.5 million. When you get to line 33 on page 3 of 5 of the attachment, which is the February 2023 New Mexico 550 report, you can see the same 7.5 million. The process of the mechanism is I'm going to recover, I'm going to offset or net that previous over under recovery against the current month expenses. So that 7.5 million on line 33 is then added with line 32, which is the current month actual fuel and purchase power expenses. And we end up with our line 35, our total fuel and purchase power expense of a credit in this case of 1.6 million. Then the third line that I'd like to show you is line 37, which is the revenues billed via the FPPCAC. And as you can see, these are showing a positive 4 million because we entered the factor, because we had that error in the billing input where the factor was entered as a positive instead of a credit. But through the process of the mechanism, we pick up the actual amounts that were billed to the customers. So then to get to the monthly over under recovery, then you take the revenues of 4 million and you reduce the fuel and purchase power expense on line 35, the 1.6. And so now we've got a over recovery of 5.7 million that you can see on line 41. So through that process, I'm showing that the December over recovery was cleared on line 33. I've given the customers, showing the customer amount that got billed of 4 million, and then now that's going to roll into the factor. So on line 43, you see that same 5.7 million divided by the KWHs, and it calculates the current month portion of the factor that's going to be billed in April. And then we have our 12-month average. And then this one, as you can see, is still a credit of 5.7. So the customers will get billed a credit of 0.019812. And then on page 4 of 5, I've also outlined footnote D, where we noted that, there was a billing input error. And through the process of the 550 and the calculation of our factor, we'll go ahead and take care of that. And we're giving the customers the proper credit for the amount that they were charged on line 37. Okay. Any questions so far?
Nope. You want to continue or?
Yes, please, if I may. So as we know, the overcharge is included in February, right, on line 37. So I want you to keep in mind line 41, which is the over recovery of 5.7 million. So when you go to page 5 of 5, which is the April 2023 New Mexico 550 report, you will see on line 33, the 5.7 million over recovery from 2 months prior being offset. So now I'm back at 0 for the month of February. And then we go through the same process again. My purchase power, actual purchase power cost for April on line 32 happened to be a credit of 1.1. And that gets added with the 5.7 over recovery. So now I've got a credit on line 35 of 6.8, 6.9 for my fuel and purchase power expense. Line 37 has the credit of 2.1 million, right? Because we are charging them based on the credit that we had in February, the factor. And when you net those two numbers, I'm at an over recovery of 4.6. And so through that process.
Wait a second, I lost you there.
Yes, I'm sorry.
Because of line 37?
Yes, on line 37, we've got a credit that we billed the customer, right? And so that credit of 2.1 million is you take the expense line on 35 and you reduce it. And so now we've got a debit balance over here of 4.6.
On line
41? 41, yes.
Okay.
Okay,
Thank
so
you.
it's still an over recovery.
Go ahead.
Okay, so you see how that little process works? And then I'm gonna show you the next attachment. If you go to attachment 3, this one is just more of a mathematical presentation or a picture, if you may, that shows the shows the components of the cumulative over under recovery by month. Okay, so I started with January so that you can see in January 2023, the current month over recovery of 7.5 million, 7,518,872 is coming from line 48 of the January 2023 New Mexico 550. And so I included just work paper A, page 2 of 4 of each of these months. So if you look at page 3 of 8, and look at line 48, you will see the 7,518,872 there. And so that's my first component of my January cumulative balance. And then the second piece is the prior month over recovery. So if you look at the December report on page 2 of 8 of the attachment, you'll see the 7,533,367. And then when you bring it over to the attachment on page 1 of 8, you see the 15 million under January on line 3. And that line 3 matches line 4. And line 4 is the cumulative over under recovery for that month. So for January 2023, if you go to page 3 of 8, you'll see line 49 shows that same 15,052,240. Okay. And so then taking you back to page 1 of 8, you can see that line 1 for the current month becomes line 2 for the next month and so forth. And so focusing specifically on February, if you recall, we had a 5.7 million over recovery that you can see there on February. That February amount rolls into March on line 2 for March. And then we've got the current month recovery of 3.9 for March, gets me a total over recovery of 9.7. And when you get to April 2023, the February over recovery is no longer there. So that's where the mechanism.
How do you know that?
Itself, because I've been able to show, if you look on February 2023, what made up my cumulative over under recovery was the current month for February, and then the prior month, which is January. And then when you get to March over recovery, then it's March and February. Then when you get to April, the 5.7 falls off the list, right? And now I'm just left with the over under recovery for April and March.
Okay.
That makes sense?
Anything further with EP Exhibit 11? Ms. Reza?
That's all that I have, unless Ms. Hurst or someone would like for me to go over the Form 550 and each of the lines on there. But I believe these two cover the February 2023 error.
Yeah, and those are basically notes that are describing what each of those lines are. Is that correct?
That's correct.
Before I leave EP Exhibit 11, Madam Hearing Examiner, we would offer that into evidence.
Ms. Reza,
Yes.
You formulated EPE Exhibit 11?
Yes, I would say the Form 550, I added those notes, and then I had one of my team members help me with attachment 2 and 3.
And it's true and correct to the best of your knowledge?
It is.
Any objection to what's been identified as El Paso Electric Exhibit 11?
Yeah, oops.
Do we have a name for this exhibit, Mr. Wexler?
Yeah, it's a supplemental discovery response to CLC exhibit RFI 1-4. And the background behind it is roughly 2 weeks ago or so, Ms. Stevens actually asked to supplement discovery responses with precisely this information. And so we complied with that and thought that because of how helpful it is in explaining these various issues, that we would include it as an exhibit.
Was this actually served in this format 2 weeks ago?
Yes, ma'am. It was served roughly, I believe it was Friday when it was
Madam
completed.
Hearing Examiner.
Hang on, Ms. Stevens. Okay, So the parties previously got this prior to you putting the Dropbox.
That's correct. I believe it was the same day. No, it was last week, and then it was put in the Dropbox on Monday of this week. Correct.
Yesterday. Seems like a long time ago. Okay. Is there any objection to what's been identified as El Paso Electric Exhibit 11?
Yes, ma'am, there is. First of all, Mr. Wexler's comment that we specifically asked 2 weeks ago, I don't know what he's talking about. We have been complaining all along that the company did not provide.
What's your objection?
My objection is that this is untimely. They are springing a new exhibit on us. It could have been, it should have been provided before a direct testimony, actually, because the original, this is it's a supplement to CLC 1-4. The responses to CLC 1-4 was issued in February. The responses were due in mid-March. The city filed a motion to compel. You ruled on it without giving specific directions as to which answers the company was to supplement. The company, that was, I think, was it the end of some point in April? The company, it's the same thing. You know, the company waited till I could prove. I have it. I don't think I have it in my exhibit.
Okay, so you're saying it's untimely.
It was served on us at 5:15 on last Thursday, with the pre-hearing conference about to happen at, I think it was 9 o'clock the next morning. And it's just, this is what should have been in the company's direct testimony, certainly should have been in their rebuttal. There's no excuse, I guess, maybe there's an explanation, but I don't think there's any excuse for hanging back and putting this out here last week. And I know you're going to overrule my objection because I understand you want the record to be accurate, but I do think that this is a, deplorable practice, and I hope that you will take that into consideration.
Very well. Any objection from any other party? Hearing none. Any
Madam Examiner.
There you are, Mr. Herman. I thought you left.
I was having trouble turning my video back on. But we'd also object just I've never seen a exhibit admitted in a rebuttal testimony, and I just think the company's direct examination is limited to providing their direct testimony, confirming its veracity, and tendering the witness for cross. So I don't see where this is permitted by rule.
Mr. Wexler?
Yeah, there's no prohibition on offering additional exhibits, particularly in redirect. And if you recall, Your Honor, what happened here in this testimony is there was a lot of very unclear questions, and as a result, very unclear answers on precisely these Rule 550 reports. And so the additional notations that were provided as part of the supplemental discovery response are going to be very helpful for both you and for the commission, particularly given now that we have an unobjected to transcript in which she is walking through the various pages, demonstrating exactly how that works. As to this idea that somehow it was sprung on us, I certainly will represent. Approximately 2 weeks ago, Ms. Stevens and I were having a conversation about Ms. Riza's rebuttal testimony. She specifically asked me to supplement the discovery responses on exactly this issue, how the dollars, the over recovery, flowed back to the customers. We were simply trying to be helpful and complying with that.
Madam Hearing Examiner, I'm not sure that's true. What I was trying
Well,
to
hang on, Ms. Stevens. Are you finished?
The responses on are why the
Well, it's not your turn, Ms. Stevens.
Okay.
Anything further, Mr. Wexler?
No, thank you.
Go ahead, Ms. Stevens.
Okay. I do not recall specifically asking for this supplementation. I think that what the city has been trying to get and still didn't get, and you will see this in another exhibit, is to get numbers, invoices, things that you were asking for, to support the fact that in February 2023, the company claimed to have negative expensive fuel and purchase power expenses and negative off-system sales revenues, and that it was all a matter of adjustments to accounting estimates. And we asked and asked and asked to get real data.
Okay, so what's the point with regard to this exhibit?
It's still,
I understand you're saying that.
It still is untimely, and I would have, if it had been put in, our testimony might not have reached a different conclusion, but it certainly might have gotten taken a different route. Yeah, it's if this is it's bad enough that the company put on most of their case in their pre-filed rebuttal. Now they're asking to put on the rest of it in redirect exhibits. Shall we, it's just.
Okay, I think I've heard enough to make a determination. While it might be unorthodox to allow a extraneous, and by that I mean exhibit not part of testimony, I believe that Ms. Stevens, you have a practice of having a voluminous number of exhibits that you either try to admit or utilize during cross-examination that weren't part of any direct or any rebuttal testimony. Therefore, I don't think that the practice of someone using some type of exhibit, whether it be for demonstrative purposes or as an effort to try to cross-examine the witness, or in the case of, for example, a filing of a different case, or the 550 filings that have already been admitted, if they're going to be helpful to the commission to understand, and then I think it's going to be appropriate to admit it. Now, there is the question of unfair surprise, potentially, that I have to think about. You got it last Thursday.
5:15, yes.
I just got it yesterday at noon. So, yeah, it's kind of late. I totally agree. But do I think that, that its probative value is outweighed by getting it at a late date? I'll think about it. I'm tentatively going to admit this for purposes of examination of the witness, and we'll consider and make a final ruling after I've had a chance to think about it for a while. But I got to tell you, I believe that the use of this exhibit, along with the witness's testimony, have provided some clarity to El Paso Electric's position in this case, and for that reason, I'm going to tentatively admit EPE Exhibit 11. You have further questions for Ms. Reyes, Mr. Wexler?
One brief line, Madam Hearing Examiner. Ms. Reza, do you have before you still CLC Exhibit 25?
Yes, I do.
If you recall, you were asked a series of questions by the hearing examiner having to do with at what point staff is notified and whether it has an opportunity to review. You recall those questions?
Yes, I do.
If you looked at with me at the cover letter, page 1 of CLC Exhibit 25, and this is the email from Ms. Novella, and we can see all the various addresses. You see that?
Yes.
The very first address there you can see is to nmprc.fuelclause@prc.nm.gov. Do you see that?
Yes, I do.
Do you know if that is a distribution list to PRC staff members?
What I believe, you know what I believe that is, and I apologize because I did not read that correctly earlier.
And fair enough. And so if I understood your testimony from before, you don't know precisely what individual staff members might be on that distribution list. Is that right?
Yes, correct. When I saw this one, I thought it just went directly to the commission. I'm not sure if it's actually staff or just someone else at the commission. I know that that's where we are required to submit it.
And then finally, Your Honor, a slightly different subject. We had some testimony earlier about staff exhibit number 3. And in order to ensure that the commission can properly understand that, that testimony, I move staff exhibit number 3.
Well, I'm not going to let you move staff exhibit. I think staff has to move its own exhibit. Let Mr. Black do some work here.
Fair enough. And I have no further questions.
Okay. Mr. Wexler, consider as a bench request number 1 to get a hold of Ms. Novella and list. I want to know who that is.
Understood.
And by that I mean the fuel clause distribution list.
We'll do that.
Okay. All right. Are we going to have any questions based on my questions? And Mr. Wexler's redirect, Mr. Herman? Need an audible?
No.
Very well. Thank you, sir. Ms. Stevens?
I have a couple, Madam Hearing Examiner. I think
Go ahead.
really quite limited. I'm a little thrown off by the last stuff that's going on here. May I?
Go ahead.
Okay, let me find everybody's faces because somehow I've got my email instead of the hearing in front of me, which is not good. Thank you. Hello again, Ms. Reza. So I have a question. I was going to ask what your counsel asked about that fuel clause mailing list. And just while you're here and actually a witness in this case, have you ever gotten a message back from that mailing list, that email address that would possibly indicate the actual individuals or the titles who receive it?
Not that I'm aware of.
Okay, well, then I guess hearing examiner's bench request applies. Would you go back to your exhibit, the company exhibit 11? Which I think
Yes.
Madam Hearing Examiner, may the record reflect that the fuel exhibits 23, 24, whatever, those 4 exhibits of those, if you look at my exhibit list, 3 out of the 4 were included in Mr. Provencio's testimonies as attachments. We're not trying to spring things on people at hearing that they haven't already seen before. I doubled them up because
There's no
sure rulings.
There was no assertion that you were trying to spring anything, Miss. Ms.
Okay,
Stevens.
I
You know,
I heard statements about the fact that city
No,
routinely.
no. What I said is is that you usually have a lot of exhibits, and I don't believe all of them are part of the testimony package. I think part of them are used for demonstrative purposes, but there was no intent in my statement to indicate that anybody tries to spring anything on anybody. Okay?
Okay.
Go ahead with your question, please.
Okay, let me go back to, if I could, Exhibit 11, and I'm working my way to that.
There you go.
Okay, I'm looking for the page. There it is, page attachment 3, page 1 of 8. First of all, Ms. Reza, why did you start at January 2023 for this summary of cumulative balance corrections?
Because I was trying to show the components of the cumulative balance in February 2023. And so I wanted to show that the line 1 under January 2023, which is the over recovery for January, is a component of the February 2023 cumulative balance. On line 2 on
Yeah.
February.
And you understand, looking at the cumulative, that your theory that each month, your point is that each month or 2 months later it goes away, but that is not resolving the issue of the large and ongoing cumulative balances, is it?
No, as I mentioned earlier, the balances can be caused by various items in the fuel cost components as well, right? Because we're taking the fuel costs and netting that against what was billed to customers. So there's a lot of moving pieces to it.
And without going through your description, which you did very well, and I think we're both too tired to do it over again. Part of the reason that calculated cumulative over recovery doesn't zero out in 2 months hence is because of the use of the rolling average methodology, isn't it?
I wouldn't say necessarily because of that specific component, right? There's other items that we have as well, right? When we are doing calculating the actual costs and coming up with our factor for the first line of our factor, right? The first component that's based on the over recovery for the month.
Yeah.
That is based on all of the activity that we had on top, right? And so that's an estimate of what we think we're going to recover from customers the next month, right? And so we never know what the next fuel costs are going to be. And on the KWHs that we bill the customers, that's also going to vary each month. And we're never going to match exactly. So the balancing account is going to basically contain all of those items that aren't zeroing out.
And the rolling portion, and I happen to be on, I don't know, work attachment 2, page 5 of 5.
Page 2, okay. Let me get there, please. Page 2. Page 2 of 5?
Yeah.
Okay.
This is probably not a good one, but the rolling component there, which is like line 44.
Yes.
If that were, going back to the old methodology, if you were using actual costs, you would be closer, would you? I'm not saying perfect, but you would be closer, wouldn't you?
I guess I don't understand the question there, because the factor that we're calculating on line 45 is what we will be billing customers. So we're charging them the full amount.
Correct. I'm saying that if instead of using the 12-month rolling average on line 44, you were using the actual monthly actual costs from, I guess, line 20, line 30, the way the old mechanism worked, you would get closer, in most instances, you would get closer to not having a huge, not having a big over recovery balance, cumulative balance, wouldn't you?
I can't say that for a fact. The 12-month rolling average is based on the last 12 months, right? And we're trying to incorporate a little bit of stability, right? As I mentioned in my testimony, into the factor that we bill the customers, but at the end, we're billing them whatever the factor is.
And the
So I
stability,
can't say that for a fact.
stability.
Let her answer the question, Ms. Stevens. Go ahead, ma'am.
You done?
I was gonna say that I can't really say that because this amount that's here on line 45 is gonna be used to bill the customers. And I don't know what the expenses are gonna be for the following 2 months, right? You know, I'm gonna bill them that in April, and I don't know how close that's gonna get to my actual cost in April, because I don't know what they're gonna be.
But you're not denying that the 12-month rolling average portion has a sort of a dampening, can have a dampening effect?
Yes, I'm not, what do you mean by dampening? I guess I'm not following the question.
Well, smoothing, I guess the word's been used in testimony, some is smoothing.
Well, and we're trying to just mitigate variability, right? So kind of if we happen to have some months where there were some above average or lower than average costs, fuel and purchase power costs, we're trying to just lump them all those together, right? So that it gets the customer to a smaller number and it doesn't really cause a big peak, right? We're just trying to do that with the factor, kind of lessen the variability by averaging out those costs for those 12 months. So depending on what direction the costs are going, then that's going to be the effect it's going to have on the factor.
Okay. I have another quick question about hearing examiner's questions to you about reconciliation. And,
yes.
And she, said that she needs to use the word cautiously, but were you listening to Mr. Schiesel's testimony this morning, or probably actually early, towards the end of his testimony, it's probably early this afternoon?
Yes, I was listening to most of it, yes.
And do you understand that he was, do you interpret his testimony as asserting that a reconciliation, as the company is using the term for the fuel clause, does constitute a prudence finding?
I think you would need to ask him that and what he means by that.
Okay, and your testimony, I believe, in your written testimony and your oral testimony, is that is not the case, correct?
In my testimony, I am saying that the reconciliation is just basically matching revenues to expenses, and for us on the accounting side would not impact us if we don't have a reconciliation.
Thank you. Those are my questions.
Thank you, Ms. Stevens. Ms. Solz, did you have questions based on my questions or the redirect?
No, ma'am, I have no further questions.
Thank you. Mr. Black, any questions based on my questions or the redirect?
Boy, I'd really like to earn my paycheck with some really good questions, but I'm going to sit back here on this one. Thank you. Thank you so much for your time, Julissa Reza.
Oh, and thank you all for allowing me the opportunity to gain the experience. Appreciate it.
Thank you, Mr. Black. And Ms. Reza, thank you very much. You are excused.
Thank you.
Did she get a gold star for showing up and testifying for her first time? Thank you very much, Ms. Reza.
Thank you.
I think she should get more recognition.
Thank you.
Very well. I believe due to the lateness of the hour, we're not going to get unfortunately, to our next witness, who we will have, I believe, Mr. Martinez, beginning at 9 o'clock tomorrow morning. Let's log in approximately 10 minutes early to see if we have any scheduling or procedural matters that we need to deal with. Otherwise, thank you all. Thank you, Mr. Lee. Appreciate you and the participants. And we are recessed until 9 a.m. tomorrow morning. Thank you.
Thank you.